Okay. Good evening and welcome to the February 15th, 2024 meeting of the Humboldt County Planning Commission. I'm Noah Levy. Before we get started, I want to remind you as usual that on page 2 of our agenda, it outlines the ways that you can follow along or participate in this meeting remotely. If you are at a computer and may wish to participate by making comment, the best way to do that is through the Zoom link, which is right there at the top of page 2. You can also watch it on the humboldt.legstar.com website, but just note that that does run a little bit behind real time. So if you're watching there and wish to use the phone to comment, you would need to jump in a little earlier than you might think. So with that, I will ask you to join me in a salute to the flag.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Before we actually have the roll call of commissioners present, I just want to welcome Jerome Kiriazi, who is our newest planning commissioner appointed by Natalie Arroyo. And I also want to thank so much Lonix Landry, who decided to step down from that role for his year of service on this commission. We appreciate you, Lonix, and we know there's a lot else you do in the community, so thank you. With that, could we have a roll call of commissioners present, please?
Commissioner Skavdal, Commissioner Levy,
Present.
Commissioner Mulder,
Here.
Commissioner O'Neill,
Here.
Commissioner West,
Here.
Commissioner Kiazi.
Here.
Okay, so we have 5 out of 7, and that is a quorum. We have a very short agenda tonight, and it sounds like it's going to get even shorter. Director Ford, are there agenda modifications you wish to discuss?
Yes, thank you, Chair. On the consent calendar, there is one item. It's ECD Holdings. And we have received a request from the applicant to continue this, to allow them to continue to work on the access road. And we concur with that and recommend that you would continue that till March 7th. So we'd recommend that you take that up as part of the consent calendar and then continue it at that time.
Okay, we will do that. Thanks very much. That brings us to item D, which is public comment on non-agenda items. This is the opportunity for members of the audience, either in person or on Zoom or phone, to comment on a matter which pertains to the Planning Commission's jurisdiction, but is not a matter on our agenda tonight. I don't see anyone in the room wishing to comment, but there are now 3 hands up on Zoom. So we will take public comment on non-agenda items, starting with the first hand I saw is 707-923-7108. Go ahead, you have 3 minutes.
Thank you. I was calling to ask about the watershed maps. They were being supplied on the cannabis cultivation permit application, which showed the watershed that the application was in and some information on what else was happening there with permits. And I think it's important for the commission to have as much information as possible to make informed decisions, and not having these watershed maps is, to me, making it harder for the commissioners to see the overall picture. So that's my comment for now. Thank you.
Thank you so much. And when we get through other public comment, I may ask the director to speak to that point. The next hand up is 5288. Go ahead, you have 3 minutes.
Thank you. This is Kent Solotsky. I would like to back what Bonnie said. I think there was only one agenda item, and I wasn't able to attend on the zoning administrative meeting. And it, I think, was just recommended due to the nature and size of the project to be brought back to Planning Commission. I guess John Ford can confirm that happened or not. My concern is there's going to be a tendency here, and you're going to see, saw it on that project and another one, to take your 10,000 square foot grows, a lot of which went through the zoning administrator, and bring them back to you for increases in size up to like 1 acre. And I just want you to our opinion in the public is this is being done probably with likely no intent of ever going forward with the project, but getting the entitlements to enable them to go ahead and market those to, I guess it would be Reynolds, Tria Glass House, I think would be one of the companies probably buying those. And this is a major concern to us. Again, like Bonnie said, we need the maps. Whenever you have a project, you're going from 10,000 square feet up to 43,000 and some or something like that. I highly hope you know that, when you're coming back, there's a new project, but you really look really hard at things such as making sure that they have road maintenance agreements, that they have, even if not required, if they have wells, that they go through forbearance and have storage sufficient. And of course, with our ongoing thing, I think generators probably are about being phased out, so if they're probably not a play because the state's coming in with that one. But I do caution you on you have a very high percentage of your grows at 10,000 feet. And I would be really reluctant for people to go ahead and be pushing those all up to 1 acre grows without really looking at the watershed and the other consequences of taking what a lot of people feel has already impacted their neighborhood and blowing these things up. So that's my recommendation as these come before you. Thank you for my opportunity to speak.
Thank you so much, Kent. The next hand up to comment is 5515. Go ahead, you have 3 minutes.
Hello, thank you for the opportunity to talk. And I believe I heard you say that ECD Holdings conditional use permit has been moved to March 7th. Did I hear correctly?
That is correct.
Okay. Well, I realize that's not on the agenda, but I want to speak about it anyway. In 2018, the Humboldt County Board of Supervisors passed.
Can I, excuse me, ma'am, we are going to discuss this item when we, not really discuss it, but we're going to have a vote to continue the item. And so I will give the opportunity for public comment on that item then, rather than now, if you don't mind.
Oh, not at all.
So
how do I remute, or you will remute?
we'll remute you. Just keep, you just keep your, well, you can put your hand up again in a moment, but I'll remember that you wanted to speak on that, okay? Thank you. Okay, and the last hand raised then for matters not on the agenda is from Ken. Go ahead, you have 3 minutes. Well, it's Ken, not Kent. So I think it's different from.
It's Ken.
But can you unmute? Yes, now you're unmuted.
Oh, sorry about that. Yeah, thank you. It's puzzling to me how we can continue to consider even expansions or permits given Resolution 1843. Now, I'm not sure if all the commissioners are familiar with this, but beginning in May of 2019, as part of the EIR, the supervisors agreed to conduct an annual review of the limits and prescribed distribution of permitting and acreage allowances that have been allocated. And without this kind of annual meeting, which has never happened in 5 years, thanks to the planning department, which is supposed to bring this up, we have not had the advantage of, and I will quote, law enforcement and other relevant officials from local and state agencies shall be contacted and invited to provide and present input and information to be considered by the board during annual review. And then, after the hearing, after considering all the information, the board may choose to establish new caps on acreage and permits, as well as change their distribution within watersheds. My question is, why have we not had these? How can you consider doing anything with permitting or expanding without this adaptive management that was mandated back in May of 2019? And I would love to hear John Ford, who's the ball hider in chief, comment on this, because it's in his ball court to bring this before the supervisors, and he never has. And so here we are considering expansion between two creeks, Duke and Norton. We have no idea what the cumulative impacts or carrying capacities of this area are, because you have been either intentionally or negligently avoiding holding these hearings. The public demands and expects to have these hearings because these allocations were made arbitrarily back in 2018. Thank you.
Okay, thank you. Seeing no other hands at this time for public comment on matters not on the agenda, I will close that section of public comment. Commissioner Mulder, did you want to make a
I
remark?
just wanted to make a couple clarifying questions to staff, if that's appropriate.
Certainly.
In regards to that. But staff might want to talk before I have even questions, I don't know.
I'd be happy to bring a report back on anything that you want to discuss, but it gets a little dicey if we start having something that's not on the agenda. But happy to answer any questions.
Just clarify if my memory's incorrect. The cap were not, the cap of projects is somewhere in the 5,000 range and we're less than 2,000. Is that correct or incorrect?
The cap is in the 3,500
35.
range. We're approximately less than a half of that.
Okay. Thank you.
Okay. Director, you're not obligated to, but was there anything you wanted to add in response to any of those public comments or questions?
Sure. The watershed maps, we have made a commitment to have provide to you, and I don't know why they haven't been in the agenda packets. We will correct that.
Yeah.
In terms of Resolution 1843, the section there was really written to expand the cap. It did require annual reports, and the presumption was at the time, and we are bringing a report back on this to the board to discuss this. We'll give a copy to the Planning Commission. But was that the assumption was that there would be monitoring being done by state agencies. And we just checked with them, that monitoring's not being done. So the information we really will have is the information that the county can collect, the county has control over, and that is in two forms. One is in what's been permitted and also what's been abated. And at this point, we've abated quite a bit. We have abated more than the commission has approved in terms of new cultivation. So we'll bring those facts and statistics forward.
Okay, thank you. Well, then, that does bring us to the consent agenda. As already noted, the only item on consent is the ECD holdings in the McKinleyville area, which is now being recommended for continuance.
I'd make a motion to continue that project to March 7th.
Yeah, I do want to, since there was somebody who wanted to comment on that. So you can make that motion.
I just thought being as the intent is to continue it, I
Yep.
thought it might be appropriate to have a first and a second for the continuance, so that way the commenter knew
Yes.
what the intent of the commission was.
That actually makes sense, sure.
I'll go ahead and second that.
Okay, so we have a motion by Commissioner Mulder, seconded by Commissioner West, to continue ECD Holdings to March 7th, which is our next scheduled meeting. But I do now want to allow for public comment on the continuance. We're not going to get into a substantive discussion of it, but if you're not able to attend the March 7th hearing, you would be entitled to make comment on this item tonight. So I'll go ahead and recognize caller 5515, who started to speak before. Go ahead, you have 3 minutes.
Thank you. I appreciate the opportunity to talk. I'll just start from the beginning. In 2018, the Humboldt County Board of Supervisors passed Resolution 1843. Resolution 1843 established caps on commercial cannabis cultivation permits and acreage. These permit caps and acreage were completely arbitrary. The caps did not include analysis of watershed conditions. The caps did not include analysis of the carrying capacity of the ecosystem. Resolution 1843 mandated yearly public hearings to determine impacts from cannabis cultivation and make adjustments to the caps that would help facilitate adaptive management. The Board of Supervisors agreed to have annual reviews starting in 2019 and to make the review and cannabis cultivation reports
ma'am,
public, but this has never happened.
Is this a comment on the continuance of this item?
Yes. Resolution 1843 states, the report shall provide, this is a quote, excuse me, the report shall provide information detailing the number and status of all applications received, permits approved, compliance agreements that have been executed, and code enforcement actions undertaken by the department, unquote. It has been 5 years and no public hearings have been held. How can the planning department approve expansion of a cannabis cultivation farm today, or on March 7th, when Resolution 1843 has not been adhered to? I urge the planning department to follow all the guidelines for cannabis cultivation farms and to prioritize complying with Resolution 1843 and thereby not accept any expansion of farms until a public hearing has been held and a cannabis cultivation report shared publicly. Thank you for this opportunity to talk.
Okay, thank you. And I have one more hand up. Again, this is a comment. Commissioner Mulder?
Can I please request that if it is not in regards to the continuance of this project or specific information that maybe need to be brought forward for the continuance of this project, that we politely ask the commenters to get to that lane, please?
Yes, sure. That seems reasonable. 5288, did you wish to comment on the continuance of the ECD Holdings project?
I do, Ken Sawatsky, and I guess my point of order was clarity. I will be out of country on the 7th, and my understanding was I did have latitude to make comments on this project. Is that true or not?
If you're not able to attend that meeting, then I will allow you to make comments on the project, yes.
Thank you. I have Magic Jack. It doesn't allow me, and it's very sketchy on the cell phone, so it's very near impossible. I know you've had a few people making comments on this other thing as far as carrying goes, these things, and I think that is important before you start blowing these things up. I'm going to go specifically to a couple things. Page 7 of 11, according to the report I have, has a quote in here, which is kind of disconcerting to me. It has CDFW commented, including a request for a condition limiting the use of heaters to nursery or insulated structures to lower electrical use. After careful consideration by staff, this condition was not added to the project because there does not appear to be a nexus to wildlife or habitat concerns associated with CDFW jurisdictional authority. Whether that's true or not, the comment apparently was voiced as an opinion, and an opinion that I tend to share. The electricity use on this particular project is through the roof. It's one of those projects that basically, it's, in my opinion, being grown in the wrong location insofar as you have so many mildew problems, you have to run all these different fans and everything else that use a lot of power. And so I do hope that you will go ahead and actually have a condition that reflects the input that you got from CDFW and myself from the public. I did also have a comment further down in the page which reads, the previously approved cannabis permits for this location require the applicant to attempt to form a road maintenance association, RMA. The formation of an RMA was not successful. Well, you know, it's, in my opinion, there's got to be some nexus here where if it's not able to be done, that's telling you something, and either the person who's actually has the change here, the entitlement, would be responsible for all maintenance. I think that I've heard a rumor that possibly the applicant has reached out, speaking with some of the neighbors with concerns, and offered to possibly pave this particular road, which would bring it much closer to the standard that would be required. Also, that some of the things required before on the report for the original permit regarding turnouts and things have not been dealt with. My understanding is the project has been water barred. The road had been water barred to the point where it puts improper water into somebody else's property. That needs to be corrected.
10
so
seconds.
Quite a few problems regarding the road. So thank you for the opportunity to speak.
Thank you, sir. Appreciate your comments. Okay, I see one other hand has come up on Zoom. That is Melanie McCaver. Again, please bear in mind that we are just continuing this item, ECD Holdings, but if you wish to comment on the continuance, or if you're not able to comment on the matter at the March 7th meeting, then go ahead, please.
Yes, hello, thank you. And I won't be able to comment on the March 7th, I believe. I think I'm at a conference then. But I did have some comments that I think, you know, are important in terms of what is brought forth at the next meeting. So I think it would be really important to obviously have the maps that should have been there, including the roads, and then also look at the resolution in terms of the carrying capacity. I think it's really important for the county to produce that documentation on what analysis was done and what data was used to get those numbers in terms of the acreages per river. And then in terms of the well, that needs to be relooked at before it gets brought back, because from what I was reading, it was examined by an engineer. And so it makes it look like the county's taking kind of a Middle Ages approach to engineering. Engineers don't typically do hydrogeology. And yes, and then in terms of the motion, if you could have the director or somebody explain to the public why the motion is phrased as consider the final environmental impact report when there are special permits and variances involved. And finally, I'd just like to say thank you for continuing it, because it had really terrible optics. It looked like it was getting pushed through because of the measure that's on the ballot. That's all. Thank you.
Thanks very much. Okay, and with that, I will close public comments on the consent calendar and remind you that we do have a motion and a second to continue this item to March 7th. And I would go ahead and invite a voice vote. All in favor, please say aye.
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 Aye. Any opposed? Any abstain? So the motion to continue ECD Holdings to March 7th passes unanimously. Okay. That brings us to old business, and the only item here is the sign ordinance, which we're returning to after last continuing it on January 18th. Commissioner Mulder.
I may not have been present in December or January, but I watched all of both meetings, so I'm well understanding of this. And you guys had some excitement there on the last one, the smoke smell and the delay of presentation in December. So.
Right. Thank you so much. Yes, Commissioner Kiriazi.
Yeah, I also want to note that I did brief myself with the last meeting, January 18th, and all of the materials of that meeting and this meeting. However, I did not review the prior 2 meetings to this, but I do feel like I'm well briefed enough for this.
And I know that you spoke with county council about the question of whether that was sufficient to participate and vote.
Yeah,
And you were told that yes, it is. Do you want to speak to that, Ms. Valeska?
Yeah, in reviewing this situation particularly, because it's a legislative matter, the due process spectrum is a little bit less for this. When it's a quasi-judicial or judicial hearing, the due process would require that you absolutely have to go and rewatch everything and make sure you're apprised of all the comments and information and evidence submitted. But in this case, he's apprised himself sufficiently to participate.
And I apologize, Commissioner Mulder, because I only learned that like this evening, that the rules are, the requirements are a little different for an ordinance than for a project case.
There was a lot of lively comment.
But you are, it's great that you managed to make the time and that you saw all the discussion that happened to date. So, okay. So with that, I think I would invite Mr. Dunn to give us a presentation on the revision of the sign ordinance.
Great. Well, good evening, Commissioners. At the prior hearing for the draft sign ordinance, staff presented the revised ordinance with alternatives and additions that had been suggested during the last hearing. Staff has been advised to provide a more thorough breakdown of the current ordinance language in comparison to the proposed language. Staff was also asked to provide examples of existing signage in the county to better understand local trends. Staff has surveyed signage on 22 sites where images were taken to estimate the sizing for each type of sign. This will hopefully assist the Commission in their decision-making and provide some background to the trends seen in other jurisdictions around California that are similar to Humboldt County. Staff has also prepared an informative table regarding sign allowances when utilizing the current ordinance in comparison to our proposed ordinance, as well as Mendocino County's ordinance, Butte County's ordinance, Sonoma County's ordinance, and All Points Signs, who we've heard as a public comment, their suggested principal permitting. So Butte County was originally chosen as a model for the proposed sign ordinance because it has similarities to Humboldt County. They're both tourist destinations, have a strong population center, similar population sizes, and have well-known universities. Mendocino and Sonoma County became good comparisons as well because they're similar in their rural characteristics, agricultural uses, unique natural resources, coastal areas, and highway connectivity. So these counties have established a sign ordinance that is a bit more comprehensive than our current ordinance and provides trends that have been followed when considering revisions to our proposed ordinance. So as a reminder, what we're primarily discussing revolves around principally permitted allowances for appurtenant signage. And this means that this is something that can be approved with just a building permit, no special permit. It's an administrative process. And people still may receive a conditional use permit if they would like to exceed the allowances in the appurtenant table if they wish. So we're going to go through some of the signage that we saw on our site visits. So we'll start off with monument signs. You'll see here on the left side, these are 2 signs that meet the proposed ordinance. They meet the square footage, the width, and the height. On the right, you'll notice that it shows the area, height, and width. These 2 signs are a bit larger than the current ordinance, or the proposed ordinance. The proposed ordinance has a 32 square foot area limit, and these 2 are a bit over that. And the height is restricted to 6 feet, and the width would be 8 feet. So these are just slightly over the maximum. And going from there, this is a portion of the table that compares our existing ordinance and other counties' ordinances, as well as the public comment from All Points Signs. You'll notice that Mendocino has an aggregate for all signage at 128 square feet. Butte County has a max area for all signage at 32 square feet and a height limit specifically for monument signs at 6 feet. Sonoma has max area of 32 square feet and design reviews required for all types of signs. Their height limit has also been limited to 6 feet and they recommend landscaping around the sign base. You'll also notice that All Points Signs recommends an area of 125 square feet, with that should actually be 2 per frontage after I've gotten some additional comment, and the height should be, or is recommended for 32 feet with no limit to the width. And this is the proposed ordinance as drafted currently. So we have the quantity 1 per frontage, 32 square feet for the area, 8 feet width and 6 feet height. And so that's something to take into consideration about whether we want to increase the area to better match some of these other signage that we see in the county, or increasing the height or width. From there, we have freestanding signs. So we have Stars, State Farm, which is in McKinleyville, and Murphy's, which is in Cutton. These would be the current proposed ordinance as alternative 2 would be limited to an area of 36 square feet and a width of 8 feet and a height of 14 feet. So Stars, you'll see, does meet the height and width, although their square footage is just a little bit large. And State Farm and Murphy's both are over the allowance for the proposed ordinance, with State Farm being within the width allowance. Moving from there, we have Ace, Eureka Natural Foods, and Ace on Harris. So there's Ace in McKinleyville and Ace on Harris. All of these signs are over the square footage for the proposed signage, and the height and width are also over what the proposed signage suggests here. And comparing that to other counties, you'll notice that Mendocino has an area square footage of 64 square feet. Butte County is 64 square feet. And Sonoma, again, is the max 32. And since there's this trend of 64 square feet, if we suggest that changing our proposed ordinance to 64 square feet, you'll find that many of those signs that we just showed as examples would meet that requirement. All Point Signs suggests an area of 125 square feet, and that would also be 2 per frontage and a height of 32. And so specifically with freestanding and monument signs, All Point Signs has the same sizing for both. So to consider them as one type of signage. And then here is the alternative 1 and 2 for freestanding signage. So next we'll go into wall signs. And with wall signs, we looked at a couple different places. So State Farm, A&L, and McKinleyville, Ace off of Central. And State Farm and McKinleyville Ace both meet the square footage. You'll notice there what they're eligible for is 40 square feet at State Farm and 100 square feet at McKinleyville Ace. Although A&L Feed would only be eligible for 100 square feet, and you'll notice there that they have 4 wall signs, with the primary building having about 55 to 60 square feet for those 2 signs, and the extended building having a sign that's 112 square feet, as well as the 15 square feet. And comparing that with other jurisdictions, you'll see that Mendocino has the similar ordinance in terms of square footage per linear foot. Theirs does not exceed 128 square feet, or it can be 160 square feet if there's no freestanding or roof sign. Ours would be limited to 100 square feet with the current proposed ordinance. They also have a projection limit for 18 inches, and our current projection limit is 7 inches. So that's something to consider as well. Butte County has a area limit of 3/4 square foot per linear foot of the building frontage, and they have no limit. And Sonoma has, again, the 32 square foot max and is required to have design review, which to my understanding, they should be able to exceed it after design review, once they go through the design review process. All Point Signs suggests that the area should be, there was actually an additional comment that was provided by All Points, and I believe for the area, it was not specified. It would be limited to the side of the building or the limit of the length of the building itself, with no limit to the quantity and a depth of 18 inches as well. And so you'll see here, this is our proposed ordinance with alternative 1 and alternative 2. Alternative 2 was created when we were asked to provide an option for maybe a little bit larger sign area based on the frontage of the facade. So moving from there, we have window signs. We have two different examples here. I have Myrtle Avenue Market, sorry, I was blanking on the name. And you'll notice that the window signs there take up much more than 25% of the window area, whereas State Farm is within the 25%. So this kind of gives you an idea as to coverage over the window area. And this is an example of other window signage that exists, and we've noticed when we did our site visits, there's many businesses that use neon style lighting for window signs. And so we made an update to the window sign portion of the appurtenant table to allow for neon style features. And these would just count towards the 25% of the window area. And these all meet that. One thing to point out is that total image down on the bottom left has a welcome sign that is actually a changeable copy sign that moves. And so those are included as prohibited in our ordinance. So comparing that with other jurisdictions, Mendocino does not specify, although Butte County does specify 25% of the window maximum, and there's no maximum to the quantity of window signs. Sonoma County has an area max of the 32 square feet, which they are requiring design review again. And all point signs suggest 100% of the glass area with no limits to the quantity. And you'll see here what the proposed ordinance that we have, which we've changed to allow for the neon signage. Moving from there, we have examples of feather banner signs and A-frame and standing signs. So this was something that came up at the last hearing, was including feather banners as part of the A-frame and standing allowances for the quantity. So we have created a separate section within the A-frame standing signs to allow for feather banners to be part of the quantity. And this just kind of gives you an example of places that might use a good amount of feather banner signs. This one in particular has 6, I believe, with 2 A-frame signs as well. And then on the top right is Mountain Mike's. They also have a feather banner sign that is out on Central Avenue. And down on the bottom right is a standing sign that's used outside of Muddy Paws, which is part of A&L Feed. And yeah.
Commissioner West, you have your hand up.
I just had a quick question. If you could go back to the last slide. So under the current proposed ordinance, would all of the existing signs be allowed, or are they exceeding the maximums?
So the standing sign on the bottom right would exceed the maximum because the standing sign would be limited to a width of 2 feet and a height of 4 feet and the area of 8 square feet. And Mountain Mike's on the top right would be allowed to have that feather banner sign if they were limiting themselves to 1 feather banner and 1 A-frame or 1 standing. The feather banners, we increased the size allowance for the feather banners to match what the standard is across the board for most feather banner signs. So the business, particularly on the left, though, they would need to remove some signage just because there's so many feather banners and A-frame signs. So.
Thank you.
Yeah. And so there's the updated ordinance there, or updated proposed ordinance there for the addition of the feather banners. And you'll notice it has a 30 square foot area allowance with 3 feet width and 12-foot height, and specifying that it cannot be placed in the county right away. And then we'll move into creative signs that we've seen. So a couple different places with good examples. You'll see that Six Rivers has a creative sign in the doorway entrance that's made of metal and a couple different emblems on it, which would meet the creative sign portion of the ordinance, and they could receive a special permit. And the wall signs there also do meet the requirement, although there are 3 wall signs on that business, and with our current proposed ordinance, it is limited to 1 per frontage. So there is a consideration of whether the wall signs should be an aggregate for the wall sign itself, wall sign square footage, that could be split up between multiple wall signs. And Next is Humboldt Cider Company, which you could consider it, portion of it to be mural and portion of it to be creative sign. I did not get the sizes for these, but I thought that these were good examples of signage that might kind of be a mixture of both mural and creative. Lastly, we have Miller's Farms, which their monument sign is larger than the allowance, although it's done well and the planter is done well. And currently with the proposed ordinance, creative signs doesn't allow for natural features to be used as part of a creative sign, although that might be something to consider given that Miller's has a good example of something that is used in that way. And so I wanted to point that out here. And something else that we have also added after doing site visits and noticing was that fuel price signs. We have prohibited digital changeable copy signs and animated signs, although we don't want to limit fuel price signs from being able to have a digital display that can be changed on the regular. So we've created an allowance to conform to the normal height, width, and area that you might see for fuel price signs, and to allow illumination, although that is something I missed in adding to the pertinent sign table was the allowance for illuminated signage on fuel price signs, which will need to be added. And here is the fuel price sign proposal. We got quantity of 2 per business and an area of 128 square feet, a width of 8 feet, and a height of 24 feet, and a clearance of 8 feet for safety purposes. And this is an overall, sorry, I'm trying to think of how to explain this, but overall, each county may have certain allowances or certain restrictions to square footage. So Mendocino has a max sign square footage to not exceed 128 square feet, except when there's no freestanding or roof sign, and so their maximum area can be increased to 160 square feet. Butte County does not have an overall limit. Sonoma County has a limited quantity of 1 attached or detached sign per building frontage on the access road, so which means that in the case of McKinleyville Ace, the access road and the building frontage on that building would be the side of the building, and so they would be limited to only having a wall sign, attached wall sign to the side of that building, unless I'm sure there's probably a permitting process that they may be able to go through to get additional signage. They also have illumination standards for internal illumination being limited to low-intensity lamps and letters and graphics with opaque backgrounds, and external illumination being screened from adjacent roads and properties. All points suggests that there should be no limit to the area overall as well. And looking at our proposed ordinance with the current limits, it would be no overall limit for commercial, industrial, and unclassified zones, and instead would be based on the individual signage from the pertinent sign table that we went through. And some of the permit allowances that people may get is a special permit for all other zones besides commercial, industrial, and unclassified with a 75 square foot aggregate, or a conditional use permit may be applied for in any zone if they want to exceed the allowances of the sign table. And so if there's any questions, feel free to.
Just on that point right there, I just want to make sure I'm understanding. So outside of those specified zones, the special permit would be required for any sign which exceeds the table baseline limits but is no more than 75 square foot in the aggregate?
No, so this is actually just a special permit is required for all other zones besides commercial, industrial, and unclassified, which is similar to the current language that is in the ordinance or in the Humboldt County Code. And
okay, Commissioner O'Neill?
So when you showed the first slide and it had the 2 that would be allowed and the ones that wouldn't be allowed, the ones that wouldn't be allowed are the ones that I liked. But I think it's sort of counterproductive if the sign is so small that, like, especially if you're an elder, you can't read it or you're distracted trying to read it as you're driving by. So I'm kind of leaning towards thinking that the signs should be allowed to be a little bit larger. I mean, what's the point of having a sign if you can't read it in the time that you're driving by? And I know there was a comment that we all have MapQuest and phones, but not everybody does. So I think we need to be cognizant of not everyone can afford that technology. On the feather banner signs, I've been looking at signs since we talked about this last, and I noticed that some are excessive. Some of those small little, mobile units that sell food have, it's a cost-effective way for them to advertise because they're not always in the same spot. So, maybe 6 is excessive, or maybe there's a time frame where they're allowed to have more than one, to establish their business, and then after a period of a year or so, they need to drop back. On the wall signs, I agree with the 25%. I hate going to like a grocery store and I feel like I'm out in the desert, and no one can see if something's happening to you because the windows are completely covered. And I think for security for the customers out in the parking areas, it's nice if there's signs are not completely covering the windows. But I kind of think that we should go up a little bit on some of those wall signs. I thought all the examples you showed were okay, except for the small signs. Those are the only ones that seemed hard for me to read, but that's just my opinion.
And those wall signs did meet the allowance for the proposed ordinance.
Yeah, the wall signs, I agree with the 25%. I think that's fine. I think that you should be able to have neon signs in your windows, and I think that we should go up a little bit on the size so that we're not, I think the examples that you gave of what wouldn't be eligible look fine to me. And I think we should sort of be consistent with that. I mean, we don't have to go to mega signs, but I don't think we need to shrink them down so that no one can read them.
Director wants to get a word in. Okay, yes. I'll recognize you, Director Ford, and then Commissioner Mulder.
Thank you, Chair. I just wanted to recommend that perhaps it would be most efficient to just kind of go through topically these and see if we can't get to a consensus on each of the different sign types.
Yeah.
Just so we can have an effective process and discussion tonight.
Sure. That is my intention as well. I wanted to allow the opportunity for sort of clarifying questions on the presentation or initial comments. Then I'll take public comment, and then I think we should get back to going through it as you suggested. But Commissioner Mulder.
So a couple of things. For me, I have a hard time seeing the different examples we got, a hard time setting policy or regulation for a functioning sign and all of a sudden saying that's not legal and possibly affecting business. So that's something internally I have a struggle with. Watching the hearings, I heard others with struggles with that. The wall signs, I think it was A&L Feed that was out of compliance, and then also their A-frame sign is out of compliance. We've had a huge hit in our economy. I would hate to set a policy that could possibly end a business. So I just want to keep that in mind as philosophically. I agree that hopefully that we can find some consensus as we go through, trying to make some of the sign sizes bigger. And then I need a clarification through the chair to staff, because I kind of, as I was following along, it's kind of was confusing that if it's existing and they had a building permit before, I can't remember the acronym, then they can keep it. But if they didn't get a building permit and it was done after the acronym, then technically it's non-conforming, not legal. Is that correct or incorrect?
Your understanding is correct, and I'm not sure of the acronym, but the term legal nonconforming is correct. So existing signs, even if a sign ordinance were to be adopted that reduced the size of allowable new signs now, those existing signs would be unaffected. Even a can sign, and they're just coming in for a face change, and I think we clarified that in the ordinance, those would be unaffected.
Okay. And what I was, the acronym, it was like this, there was something about the sign, I can't remember, but that's the acronym I was going back to, wherever the sign, I'm drawing a blank.
Okay. Mr. Dunn, did you get through your presentation or not quite?
I have a few more slides.
Yeah, no.
I apologize. I was, if you guys have any questions in between, feel free to
Sure.
ask.
I think, no, it's actually great that you've added a lot of detail, a lot of photographs of examples, and the tables comparing to other ordinances is very helpful. So please proceed, and if we have questions in the interim, we'll raise our hand.
Great. So next thing we have here is roof signs. So we brought this as examples since I know this was something that was brought up at the last hearing about whether we want these to be prohibited or not and how we would limit them. So these are just 4 places with roof signs. The storage unit already had that sign prior, and part of it was removed, and it wasn't anything new, but that's just had already been there. Mountain Mike's is the newest one, which we went over some of their allowances with the permitting for that, and whether they should be using that space for signage or using the dedicated space, as the director has spoken to before, for that specific property. And so the other things that we have added here for the applicability section for no permits required was the installation of historic plaques. Next, we have the design center section was clarified to make sure that we're not limiting businesses from being able to have lighting past sunset if they are continuing to stay open, as well as allowing neon signage or certain lighting allowances with the window signage. Next, we have the existing billboard section, and we redefined the placement portion for section I of the re-erection of destroyed advertising displays, where destroyed is defined, and we defined destroyed. It's defined as damage to the extent it loses functionality so as to be rendered useless and can no longer function as an advertising surface. And these are situations where it would not be allowed to be reconstructed, and in there we created conditions where placement will be allowed, and that would be in situations where the destroyed sign is due to natural forces and it's not located within bodies of water, flood hazard areas, streamside management areas, sensitive habitats, scenic resources, and wetlands, and they would need to retrieve a conditional use permit with a term limit of 15 years, as the general plan states, and be issued a building permit. Placement cannot be limited for billboards that have been destroyed due to vandalism, which we made sure to clarify here. That's also included in the general plan, and does not lose its legal nonconforming status. And so lastly, I know that obsolete signage was brought up, and we wanted to provide an example of something that has a property that has obsolete signage, and we went ahead and added the limit for sign frames that haven't been utilized within 5 years for safety purposes and for just dilapidated over time. And this gives an example of something that has not been in use for quite some time and has shown to rust. And I believe that is the end of my presentation. If you have any questions, feel free to ask. And I can also go back in the presentation as well.
I think we will want to go through this all, section by section.
Yeah.
But are there any questions about the presentation at this time? Yes, Commissioner Kiriati.
I don't have thank you for the presentation. Not specifically, more of just a process question. Are we specifically addressing those sections that have been amended since the last meeting, or are we addressing the entire 8.7.2?
Well, we are, we're going to focus, I think, the discussion on the changes and updates and alternatives that have been made since the last meeting. But that said, all of this is still open for discussion, and I want us all to feel free to comment on any part of even the parts that have not changed since last time. Director Ford, did you want to come on?
Yeah, I just wanted to add to what I think you said and make just something clear. We also recognize that there were some size issues with monument freestanding wall signs that the commission probably wants to discuss. We did not change those. but we recognize those are policy discussion items for tonight. And we should walk through those item by item and really talk about the sizes.
Yeah, so good question, but really, we're going to go through it all. So, Commissioner West.
I have another process question. We've talked about this item several times now. Is staff prepared for us to finalize and adopt this tonight if we are so prepared to?
Yeah, I think we would be, yes.
Okay, great.
Yeah. That's my hope as well. Okay, but at this point then, I would like to, before we get into the sort of line-by-line discussion of the ordinance, I would like to take public comment on this item. And so if you are following along on Zoom or phone and would like to comment, please raise your hand. Okay, the first hand that goes up is Jeff Wills. So thank you for your comments that you've submitted, and go ahead, sir. You have 3 minutes.
Thank you. Thanks for the time. And thank you, Jacob and Mr. Ford, for including all my comments and everyone giving me the time to address these. Just with regard to the most recent thing about finalizing this and voting on it, some progress has been made, but specifically 87.2.10.3, the placement of billboards, still is not conductive to my business, and really Section 2 is added some stuff, and I appreciate that to try to make conditions where billboards can be re-erected, but it still does not work for my company at all, and it would be a huge detriment to my company. And a question with Part C there, the conditional use permit of 15 years. As I understand it, conditional use permit takes, well, around 6 months to acquire. We have a ODA rule, Caltrans, that states that we have to have our billboard up within, I think it's 60 days of being damaged. So that would definitely have to be tweaked and modified to make sure that we could acquire a conditional use permit within the time frame that Outdoor Advertising Act mandates that we get our board back up. So really, I urge you to not finalize this yet until we can either address these items point by point together, which I can't do in 3 minutes, or I can work with staff further to make it so that section of the code can actually work with what works with our local business needs. For the rest of the discussion about the assigned tables and stuff, I've already provided all the feedback, and again, I really appreciate it being actually put in the tables for you guys to look at. And I'd just like to remind staff on this and Planning Commission on this that we're coming from a sign code that basically had no limitations here. And look around our community, you know, we just have pretty much standard signs that you see in any community throughout California. So to change our sign code to, you know, in some cases be, you know, going from 300 square feet to a proposed 32 square feet for monumental freestanding signs. That's a gigantic reduction from the status quo from Humboldt County for the last 100 years. And, you know, I don't think we have any signs that are sticking out around our business community that are just like, we can't have that here. So keep that in mind. And, you know, I'll be listening this whole time. I don't know if it's possible, but I sit through these meetings and I hear lots of questions that I could easily answer. So if possible and needed, I'm available for that. Thank you.
Thank you very much. Okay, and the other hand I see raised is Jen Colt of Humboldt Waterkeeper. Thank you for your comments, and go ahead. You have 3 minutes.
Hi, thank you so much. And I just want to commend the staff on a very thorough presentation and analysis of sign ordinances in different counties, and would like to encourage the Planning Commission to adopt this or recommend this to the Board of Supervisors tonight. I think this is the 4th meeting, maybe only the 3rd meeting, but you know, there's been a lot of back and forth and a lot of discussion, and it's really important to people in our county who rely on tourism and the scenic beauty of our region, especially in the coastal areas. You know, there are some coastal counties that have banned signs like this, or, you know, have not all signs for on-site businesses, but have banned many types of signs decades ago. So we're way behind the times. A lot of these signs in McKinleyville are way outsized for the small road that Central Avenue is, and I believe that not all of them even ever got permits in the first place. So thank you for your work, and just, you know, hope you bear in mind that as always at these meetings, the only people who show up typically are the ones who are upset. So you can count the tens of thousands of people who aren't upset and are therefore not at this meeting. And, you know, they spoke out loud and clear during the general plan update that we want to protect our scenic beauty of our county. Thank you.
Thank you. Is there anyone else on the phone or Zoom wishing to comment before we close public comment? Okay, seeing no other hands up, I'm going to close public comment now and bring it back to the commission to get into this now in more detail with staff. I will, yeah, I think we'll maybe wait about a half an hour till 7:30 or so to take a break. But as already stated, we really, all of this is up for discussion. There were some points that we had questions or concerns about in the past that haven't actually been revised, I think, in this. Is it the case that all of the sections in the one of the versions of these that had the yellow highlighting, that's indicating the things that are new or changed since the last iteration, correct?
That is correct.
Okay. But really, I think we should just walk through it. And, you know, we have a couple of commissioners who weren't in fact able to be present for those earlier meetings, and others of us that may have concerns that weren't addressed. So why don't we basically go through it section by section? And maybe you can put it up on the display as we do move through it. Yes, Commissioner Mulder.
Clarification, are we all in agreement that once we get past, kind of like we did the STR, once we get past the section and it's the majority consensus, that's where we're going to land with that and move on to the next section? Is that kind of the process we're going to do the same?
Yeah, I think that's what we want to do. Try to make the comments at the time that we're discussing that section. I mean, I think there may, I don't know that this will happen. It may be that something later on in the ordinance causes us to rethink the meaning of something that was earlier, so we won't, you know, forbid that. But for the sake of an orderly process, I think we want to try to say if we're okay with it, we move on to the next thing.
Yeah.
So, just beginning at the top, we did, in earlier meetings, shorten the purpose considerably and then decided we wanted to put it back to probably how it was originally with maybe only minor modifications. So it hasn't changed since the last time. Is everybody okay with the purpose provision? Okay. Sure, Commissioner Kiriazi.
I think I'd be okay, certainly, with moving forward the way it is. I did want to make a comment that in general, I think the assumption through 87.2 is that signs serve drivers. And in fact, signs serve people regardless of how they're moving about. Pedestrians, scooters, bicycles, any sort of way that we move. And so, you know, I think it could be edited a bit to sort of consider the fact that signs serve people, not vehicles. However, I'd be okay with the way it is. And then one last comment is I did catch in a couple of places where in subsections of 87.2 where they state that that particular sign shall conform with the purpose of this section. But I think the intent is that everything in here conforms to the purpose of the section. So I was proposing that we simply add a statement that all signs and nameplates shall conform with this purpose. And then there's no reason to restate that.
I noticed that as well, and I think what you're suggesting makes sense. What do you all think of Commissioner Kiriazi's suggestion that we state up front that all signs governed by this ordinance must comply with the purpose? That makes sense?
I'm in support, yes.
Okay. Director or Mr. Dunn, does that make sense to you?
Yeah, makes total sense, and we can absolutely do that.
Okay, sure. Okay.
I was wanting to be responsive to the idea that signs serve people. And so is that to the exclusion of item number 3, or would that just add a fifth element to it, that signs are really designed to help people navigate?
Yeah, I was, for example, instead of saying the free flow of traffic, perhaps the free flow of people, or something along those lines. And then instead of trying to specify out who's being protected, we just simply say that these signs will not result in an increased risk of injury or property damage, rather than specifying, who we're trying to avoid injury of.
Appreciate the suggestion. I guess I'm not reading that provision to imply that signs are only serving drivers or vehicular traffic. I think, the other purposes, the other provisions of the purpose seem to be broad enough that they would, I don't object to saying they serving people generally, but I sort of feel like that's implied, and I do feel that number 3, which speaks to the free flow of traffic, is there because that is one fundamental concern or risk that I think this ordinance is seeking to address, is the risk that distracting signs could cause traffic problems, accidents, injuries. So it's a subtle distinction. That's my take. Commissioner Mulder?
So when we originally looked at the purpose, 3 meetings ago, so this is our 4th meeting of it, there was a lot of discussion about this, and in that discussion, I hear what you're saying, but I'm viewing it differently, if that makes sense. And I'm good with the way it is, and I'm kind of not wanting to change it. But I do hear you and understand that people can read the same statement and have a different understanding of it.
Other thoughts on the purpose, or on Commissioner Kiriazi's suggested changes?
I think I could go either way with this one.
Okay. No, well, I listen, any and all suggestions are fair game, but I think if there's not a consensus that needs to be changed, then we'll leave the purpose as it is. However, we take the point and we'll implement your suggestion that it should be made clear that it does apply to all signs governed by this ordinance. Okay, so moving on then, applicability, where we do have a number of changes, well, a couple of changes. And actually, yeah, okay. Maybe applicability, well, I was just wondering if the line about purpose applying to all signs should be under applicability, or, I'm not sure where to put that exactly, but.
I'm sorry, could you repeat that?
Well, the question of wanting to remove a couple of places where we're now saying, so long as it's consistent with the purpose of this ordinance, and put that in a more general way up front. I just wasn't, and I think we all agree that that makes sense. And I was just wondering if that should therefore go under purpose or under applicability, or where to put that. Do you have a thought?
Personally, with that suggestion, I could see it going under applicability, included there.
Okay.
That all signs shall conform to the purpose statement. That's part of the applicability.
Sure.
Can I ask a question?
Yes.
If I had a sign that I had put up that didn't have a permit, is there anything in here that's going to prevent me from wanting to keep it updated and like I let it go into disrepair because I don't want to come before you and get a permit because it won't be permitted? Am I making any sense?
Yes, and one of the dangers that you would run there is that if there were ever somebody that were to complain about it, or if something happened on the building where you wanted to do something and the sign wasn't permitted, it would at that point have to be permitted.
What I would be concerned with in here is that we would not let, like there was the abandoned signs or the signs that have gotten to be, so in such disrepair that we allow them to continue, and maybe because I don't want to come in and get a permit or start all over, I just let it fail.
I think when we get down to the section that Mr. Dunn put up on the screen in terms of obsolete and abandoned signs.
Or those that are in such disrepair that, they're not being upkept
Right.
properly. Just thought, I don't want to hold up. Okay.
So if I could just to summarize. In applicability, we're going to say that these regulations shall be applicable to all signs in all zoning districts, and then add a provision in that all signage is, well, it may say it right there. We may not need to say anything else. And just remove all the other applicability language that is surrounding this.
And if I may, through the chair.
Yes.
Part of the purpose, or adding that things need to be comply with the purpose statement, is to add add language so that it informs planners who are doing the permitting process to make sure that whatever they're permitting does comply with the purpose statement, just to reiterate the need for that.
Mm-hmm.
And that was the intention behind that.
Yeah, so Commissioner Kiriazi?
Yeah, I mean, I feel like a section starts with a purpose. The intent is that's the purpose of that section. So I think I just brought it forward since I saw it being repeated later on, that if you wanted to state that, it should go at the top. But I personally believe that that's the whole point of putting a purpose in the first place.
Okay. I guess I'm fine either way. I think it probably, but it certainly doesn't hurt to have something that clearly states up front that everything must comply with the purpose.
So the direction is to remove specific sections that, okay.
I think that we'll get to the places where there's specific language elsewhere saying that, which was what sort of raised the question of, well, why are we saying it here? Doesn't everything have to comply with the purpose? So, yeah, I see no harm in putting something either at the end of the purpose section or under applicability that just kind of underscores that this should govern the permitting of signs under this ordinance. So, okay, Commissioner West.
Before we move on, I just at the top, wanted to express my appreciation for all the work that staff has put in. I really appreciated being able to see some of the signs that happen in real life and have a table to compare to and other ordinances to compare to. So thank you for what looks like an extensive amount of work. So it's been really helpful. And then I am also excited to see language added to the applicability for like clarity when a permit is not required, especially for historic plaques. I hope to see more of those pop up. So it's nice that they can be done without much of a process.
Great, and I second your appreciation for all the work that went into this presentation. It was really, really helpful. Now, since we're under applicability, no permit is required for those specific circumstances, but then it's also the case that in commercial or industrial zoning districts and unclassified, basically jumping ahead a little bit, we haven't quite gotten there, it says signs shall be principally permitted. Does that mean no permit is required? Or it means simply that, I mean, they still have to get a permit, but it's a ministerial permit, there's no discretion required.
So if I could.
Yes.
I think the way this is structured is that when something is principally permitted, they just come straight in for a building permit. Part of the building permit is the planning division signing off on what's essentially a zoning clearance certificate, which says, yep, it complies with zoning. What we're trying to say here is that if you're just changing the face of a sign, you don't need a building permit.
You don't even need that.
You just change the face.
Got it. Okay, just wanted to clarify that. Okay. Well, shall we move on to nameplates then? Oh, yes, do you? Go ahead.
One, that is how I read this section as well. So thank you for clarifying. And then two, I was a little bit confused by the word legal in the first one. What is a legal existing sign face, one that conforms to what would be principally permitted?
Yeah, so that would be a sign that either existed there prior to the requirements for a permit or actually has a permit, so it'd either be what we call legal non-conforming or it would be legally permitted. It'd be one of those two things.
Whereas something that, what would be an example of an illegal non-conforming sign that this would not allow them to simply change the side face?
A sign that was put up without any permits and exceeded the size that's allowed in the ordinance at the time it was put up.
At the time it was put up?
Yep.
Okay. Okay. Well, thank you. Okay, then.
One question.
Yes.
So if you had a historical sign like A&L Feed, I imagine that sign's been there for a really long time. It may not have originally been permitted. Is there an exception for something like that?
Well, that sign can continue to be there for as long as it exists.
Okay.
That is we're presuming a legal sign. And so legal signs can be maintained. They can't be expanded, but I mean, they can repaint it, they can refinish it, they can redo it, they can continue to maintain it and keep it there in that exact same configuration.
Okay. Well then, moving on to nameplates, we do have some specific details that are now added here.
And if I may, through the chair.
Yes, please.
These actually were the same language. It was just at the last hearing, it was recommended that we reposition 87.2.3.1 for all other zones, all other zones.
Reordered them, yes,
Right.
for clarity.
That is
Yes,
correct.
right. Thank you for reminding me of that. Any comments here? Any questions? Okay. Then let's move on to temporary signs. Now, did we, in the last version of this, were feather banners categorized here under temporary signs? I know that they've now been moved to A-frame and standing. I'm sorry I do not have the last version of this that I marked up. I thought I had it with me, and I don't have that on me, so
It was not specifically stated as feather banners, but I would assume that strings or individual banners would include feather
yeah.
banners.
I just want to make sure that we're, okay, it does say individual banners, but we're not going to interpret that to mean feather banners. They're treated separately in the table.
As an appurtenant sign for the sale or purchase of
Yeah.
the business.
Yeah. Okay, so this would be, right, not an appurtenant sign, but other sort of special occasion signs, which could include a feather banner or something like that, and then it would be treated differently than appurtenant. Okay, just wanted to make sure I understood how those interact with each other. Anybody have comments on the temporary signs section? Yes, Commissioner Mulder?
One point of clarification, it is election season, so you see large signs that are more than 32 square feet. Would political signs that are technically be non-conforming if they're bigger than 32 square feet? Because the way I've read this, I'm kind of a little bit confused on that.
That is correct. So if there's a concern of the sizing there, that may be subject to change, if you feel.
So, I mean, personally, I'd like to see, I mean, there's a lot of signs that are, I mean, politically related that I think should be allowed more than 32 square feet, in my opinion. Temporary signs for everything, maybe not, but if it's basically up for 90 days for an election, or 90 days before an election, 10 days after an election, I think 2 sheets of plywood, 64 square feet would be more, you know, an 8 by 8. The 32 square feet is like a sheet of plywood. I think where a lot of that gets, like, people get plywood and painted it back in the day.
Right.
So I'd be intrigued to go to 64 square feet for political signs.
Yes, Commissioner West.
I don't think I'm quite there. I think I'm for political signs, but it does get to be quite distracting and quite a lot. And I mean, when my brain, I was like, wow, 32 feet is fairly big. That's a sheet of plywood, which you can get a lot of eyeballs on that. So I think for me, I'm comfortable at 32.
Commissioner Curriasi, you had your hand up maybe about something else here, but did you want to?
I think I could go either way. I would be okay with either.
It evens the political playing field, I guess, if everybody's the same size. Can't spend your money on bigger signs, but isn't a sheet of plywood 4 by 8?
4 by 8, yeah.
32.
32.
Okay. That's pretty big.
I've seen quite a few signs that are more like 2 sheets of plywood right now. So that's what intrigued me of this, and I read that and I figured rather than emailing, I'd just clarify it at the hearing because, so if there's only, it seems like that's a coin flip, then I'm not gonna, you know, hang my hat on it, but if there's consensus, I'd be willing to intrigue it, but.
I think a 4 by 8 is big enough. They can put up more signs.
Okay. Well, you know, I could probably go either way on this one. But, so I don't know if we want to actually have a straw poll on this question of whether to take Commissioner Mulder's suggestion of having, of expanding the allowance, doubling the size allowance for political signs in particular. Commissioner West.
I think, for fairness, I feel like if someone is suggesting something that we should take a straw poll on
Yeah.
it, I think it's a good precedent to set.
Yeah. Okay. Then let's, all those who would support changing the political sign allowance to 64 square feet, specifically for temporary political signs, please say aye.
Aye.
Aye. All those opposed, say nay.
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 Okay.
That's what I heard. So thank you for officially doing it. That's kind of what I heard before we did that. So
Yeah. Okay.
it does do good for, like, sometimes we're off in our guesses.
Absolutely. Yes.
And I'd hate to like accidentally silence somebody's idea by not voting on it.
Sure.
So I think it's
Yeah, and that, thank you, and anyone else, if I ever seem to skip over that and there was a desire to take a straw poll, please just stop me. Okay, so then, okay, then I guess we move on to,
You have one other.
oh yes, Commissioner Curriasi.
On the first one, it says, the first sentence, it says similar devices for business openings, and I was assuming this isn't restricted for businesses, that these are events. They could be openings, they're sales, they're events. So I was just curious if this was intended to be specifically for business.
I believe it's supposed to be intended for, it's a mixture of business openings, temporary sales, and events, just general events.
Well, so I'm not totally sure if I understand what you're asking about, because there's temporary signs under subsection 3 for special events. But are you?
That's a good point. Yeah. So I think I was reading the first one as specific to businesses, and then the third one as anything else. And so I had actually considered just removing the third one and not specifying the first one for business. But I didn't know if there was a reason to specifically address businesses and then have a second one addressing non-business events. I was just curious.
Mr. Dunn, do you want to speak to that?
That is correct. That is how it reads. The first one is for businesses, while the third section does specify for public agency and nonprofit organizations.
What if I'm just selling Girl Scout cookies or having a garage sale? Where do I fall?
That's what I was trying to get at. Thank you. Yeah.
Girl Scouts would be a nonprofit organization.
Or if I'm just having a garage sale?
So that would be typically in a residential zone, which is maybe not clear here, but that's not something where we would expect to see a sign put up 30 days in advance that you're having a garage sale. I think this is really, again, focusing on the purpose, trying to get to businesses and nonprofit organizations.
So that wouldn't apply?
No.
Okay.
So just to be clear then, this would not prohibit people putting up a sign for a yard sale?
No.
No, okay. Are we comfortable with this division into the three subsections? Yeah, okay.
I shouldn't say this, but I'm not sure the neighbors would appreciate a 32 square foot yard sale sign put out in their front yard.
Right. That's a fair point. Yeah. Okay. You know what? It is actually 7:30 now, so why don't we, before we turn the page and go on to the next section, why don't we take a 10-minute break? that Thomas can rejoin us soon. Okay. Did you want to make an introduction?
Yeah, I do. Thank you,
Recording
Chair.
in progress.
You may have seen Elizabeth Schatz before. She has been with us in different positions, but she's currently now serving as the supervising or planning manager for the long-range planning team. And so she is taking this over, and you will be seeing her associated with the long-range planning work.
Great. Well, we are excited to be coming into a phase of dealing with more long-range planning projects. So we'll be seeing more of you. Thanks. Okay. All right. Well, we are just getting back into session, and now Commissioner Mulder is here. So let's go ahead and move on to property sale signs, page 2 of the document, on the version I'm looking at. So I don't think we necessarily need to discuss every provision if we're all clear on it and have no questions about it, but are there any comments, questions on property sale signs? Okay, I'm fine with that as well. Okay, then we get to appurtenant signs, which leads to the table that follows. I think it would be useful just to walk. This is sort of so fundamental to the whole thing that it would just good to walk us through this section as we go into the table, which we'll then discuss in more detail.
Yeah, so going to, or starting at the beginning of it, 87.2.6. So this specifies the use of these signs for advertising a place of business or a product when you're conforming to the requirements seen below. So 87.2.6.1 through 87.2.6.5. Starting at the first section, 87.261, this specifies the prohibition of appurtenant signage within residential zones unless otherwise allowed with a use permit. So for some background, there are churches and other businesses that may exist in residential zones. Most of the time it's churches that you may see. And the current ordinance does not allow for signage in residential zones under any circumstance. So this opens up the opportunity for churches or other businesses that might operate within residential zones to have a signage with their conditional use permit that would allow the use.
So it's prohibited, but anyone can seek a conditional use permit to place a sign in a residential zone. Okay, not just churches. We're not specifying who.
No,
but
this will be just for any of the conditional use permits allowances that exist for residential zoning. So you'll see in the residential zoning section for different residential zones, there's different conditional uses that are allowed. And so this is with those conditional uses. Once you seek that permit, you'd be able to be eligible for signage with
yes. Okay, that makes sense. Yes, Commissioner West?
With short-term rentals, would they be allowed to have a sign as it is written right now?
The director's
with a conditional use permit.
Not all of them need to pursue a conditional use permit.
No, and typically one of the things about short-term rentals is you don't want them turning into being like a real commercial use. The idea is to try to allow that transient occupancy use, which is a commercial use by nature, to blend in with the commercial zone. So to have signage out in front of it would start to change the character of the neighborhood, and that's what we're trying to prevent.
And if I may add to that, nameplates are allowed in residential zones.
So if it was called like the Daily Inn or something, or the Daily House, that would be okay already, because it's a nameplate?
If it meets the requirements of the nameplate, yes.
Sometimes they have it out front, you know,
Mm-hmm.
because it's a historical house.
The requirement for nameplates does require that it's attached to a structure. Yes, so they shall be principally permitted on existing structures pertinent to any permitted use. So if there's some kind of structure that's closer to the frontage of the property, that
Well,
is.
sometimes they're just, you know, little posts out in the yard, and it'll say, you know, it's like a historical house or something. I've seen those around Eureka a lot, and I don't think you should prohibit that. It may be an Airbnb or in, I don't know, but it may just be designation.
Mm-hmm.
It's a low-profile kind of sign on posts, 4x4s.
So we exempted the signs for historical designations.
So that would fall under
Yeah,
that.
and then a nameplate on a house would be allowed.
But what I suggested, would that be allowed?
So like a post out,
Usually it's 2 4x4s, has a little sign that says, you know, the Daily Inn or something like that.
that would only be allowed with a conditional use permit.
And if it was in a residential area, it'd have to have a conditional use.
Correct.
What about those that are already existing?
Well, if they're existing, they were never permitted because they're not currently allowed.
So they'd have to come in and get a permit or remove them?
Correct, although, I mean, we don't drive around and look for violations. So if somebody that lived in the neighborhood didn't like that sign there and reported it, then we'd contact them and say that the sign was never permitted and what their opportunities are to make it legal. Under the new ordinance, they could get a use permit to do that. Under the existing ordinance, it couldn't be permitted.
Just since we're talking about this point about nameplates, and I'm looking back at the nameplate section, it doesn't seem to say, I'm not reading that it says it has to be attached to the structure. I mean, unless nameplates shall be principally permitted on existing structures. Does on mean like attached to the building? Is that how it's being?
That is, yes.
Maybe we want to.
I think we should change structure to building.
Mm-hmm. Mm-hmm. Yeah, and I, just because on could be read to mean different things, maybe even attached to, if that's what we're actually interpreting this to mean.
So I could suggest when attached to existing buildings, a permanent.
I think that would clarify it. Okay. Okay. Sorry for the diversion back to the previous page, but
That was a point in case where it was important to bounce back for
yeah.
clarification.
I think so, yeah.
So if you'd like, I can move to the second section.
Yes, please do.
So section 287.2.6.2, that is referring to the table, the appurtenant sign table. So we'll go through that in a moment. But this is specified for commercial or industrial zoning districts or unclassified zoning districts when it's accompanied by a commercial services or industrial general land use designation. And so going down from there, all other zones, so aside from the residential zones and commercial zones and industrial zones and the unclassified zones, they shall be allowed up to 3 single-sided or 1 double-sided and 1 single-sided sign, not over 75 square feet in the aggregate, with a special permit. And there's an exception when the site utilizes a master sign plan, which would allow them to exceed the sign sizes that are shown on this section.
Mm-hmm.
And the master sign plan also allows people to exceed the appurtenant sign table.
Does the county have a good historical record of permits from the past? Because I know I've had that problem with well permits. Sometimes the county can't find them, or, do you guys have a good inventory?
Of sign permits? Yes and no. I mean, depending on how old the signs are, quite honestly. If it gets before our electronic record-keeping system, they're in a card file, and then if it gets before that, which is really old, it's a little iffy. But at that point, we'd probably determine the sign to be legal non-conforming.
Mm-hmm.
And so moving to section 87.2.6.4, this is the section that allows for a conditional use permit to be sought if they would like to exceed the allowances in the appurtenant sign table, and would be, so I think this is probably that part where it says consistency with the purposes of this section. So, and I think that may be what had been pointed out earlier on.
Right.
But otherwise, this section would just be the allowance for signs that aren't consistent to be sought with a conditional use permit in any zone.
And who approves the conditional use permit? Who approves the conditional use permit?
Planning Commission.
So all these sign things are going to come to us?
If they don't comply with the sign ordinance, correct.
How many do you think that's going to be? I mean, are we going to be spending all of our time?
Maybe 2 or 3 a year.
Okay.
I'm curious, what do you base that guess on? I mean, I just don't know how we would.
It's not like we see a lot of new signs.
Mm-hmm.
And even some of the signs that we see, like the new one for the pizza parlor there in McKinleyville, that's within a center where there would be a master sign permit.
Mm-hmm.
So once the master sign permit's approved, it's just reviewed for conformance with that.
Mm-hmm.
If people want to just get a sign, and if we size signs appropriately as we go through this, it should be that, most of the signs can just be approved administratively.
Mm-hmm.
And it basically, that then encourages people to identify their expectations with their signage with what is allowed in the ordinance.
Mm-hmm.
And so then only those people who really need or feel like they want to go big, so to speak,
Mm-hmm.
would be applying for a conditional use permit to come to the Planning Commission.
Yes, Commissioner Mulder.
Well, it sounded like from the previous hearings, there's 2 coming up once this is passed.
Remind me.
If I remember hearing there, I think there's a church and then also a mini storage.
Mm-hmm.
So if I could be
Yes.
responsive to that, the church absolutely is coming to you at the next meeting.
Mm-hmm. Okay.
And I'll just leave it at that. The mini storage, the signage there has been worked out. That's within a center that has a master sign plan.
Right.
They are putting the signage up consistent with the master sign plan, and so that doesn't need to come to the Planning Commission.
Okay.
The only issue is that now big is smaller, so it could come up more frequently, because if they're trying to make a sign that's consistent with what's in the neighborhood, but now our requirements are half that size, then it could come more frequently to us because we've reduced the signage size. Does that?
I think that's an argument that would be made by people who want to see bigger signage.
To be consistent with.
But I will say the overall trend in sign regulations is to move towards smaller signage.
I guess we'll only find out.
And so on the subsection .3 of this, which specifies that certain signs would be allowed with a special permit. Would that be handled administratively if there's no known controversy or?
A notice of intent to approve would be issued, and if any neighboring properties had wanted it to go to a public hearing, they may ask for that.
But if they don't, it wouldn't come to a public hearing. It wouldn't
No, it
require
would
that.
not.
Well, and even those can go to the zoning administrator for a
Right.
public hearing.
Even if they do, yeah.
Yeah.
Mhm.
And technically, some of the conditional use permits can too.
That was my next question.
I mean, if it's something that's not going to be controversial and really is kind of a request that makes sense, we would probably send that to the zoning administrator.
Okay.
If it's something that's going to fill the board chambers with opponents, no, the zoning administrator is not going to act.
Certainly. No, that makes sense. But I mean, back to Peggy's question, even some of those CUPs that may be requested, if they don't have controversy, they wouldn't necessarily come to the planning commission. So,
Yeah.
okay. All right. Well, thank you for clarifying that. Any other questions on this before we move into the table?
Great. So we're comfortable with 87.2.6.1, 2, and 4? Or, sorry, 1, 3, and 4. And then point 2 will move into the table.
Point 2 will move.
Sorry, I didn't mean to confuse.
Yeah.
So moving down, we'll go into the appurtenant sign table. I guess we'll start at monument signs. If you need me to pull up the examples from other jurisdictions or anything like that from the presentation, I can.
So it may help here for the commission to think about the difference between a monument sign and a freestanding sign, because those are both pretty similar.
Mm-hmm.
A monument sign is typically a sign that is lower profile and literally is a monument that sits on a base and kind of is low and is intentionally smaller profile. A freestanding sign can be a little different, can be elevated a little bit more off the ground. Some jurisdictions don't allow freestanding signs at all. We're not proposing to not allow freestanding signs. So it's really, what is it that the commission would want to see in terms of what's an appropriate amount of signage. One of the things that I found interesting about Commissioner Kwarzi's comment about signage for people is that sometimes we lose track of human scale when we're putting signs in. And we put in, traditionally signs were put in to be 50 feet tall so you could see them from 2 miles away.
Mm-hmm.
And I think that overall signage has moved away from that in most areas, except for along freeways. And so, like along Central Avenue, along Myrtle Avenue, what's the scale of the signage that you would want to see, and what's the environment that is trying to be achieved there? Those become the questions that need to be considered as part of the signage.
Mm-hmm.
I think you should be able to read it as you drive by. You don't want to run off the road trying to read the writing. And I would have a question about frontage. What if you're a corner property? You might have 2 sides that could be considered frontage. Is that limiting you to picking which one you think is the front?
If you scroll down to the, so I thought we did say 1 per frontage.
Yeah, it's there.
Okay. I
So,
was just looking at the table.
yeah, no, I think that's just want to be clear that in that hypothetical, if it is a corner lot and that's 2 frontage, so they could have 1 on each side, okay.
Yeah, there would be 2 frontages there.
Yeah, I don't know if there's been any kind of, I'm sure there has, studies on what is a font size that you can read driving down the road.
There are.
That would be reasonable and not make it so small that people can't read it. I mean, what's the point?
So again, just visualizing what 32 square feet is that's essentially the size of a sheet of plywood. And so, you know, and we're identified 6 foot maximum height here. And those are obviously, the desire there is to keep a lower profile sign that would be in keeping with a yard, an area that isn't trying to put a sign way up in the air.
What about when they have a sign and then they sometimes have a little, like underneath it, like they might have the address or doctor's names or something like that? Is that the whole thing, or?
It's all the sign area. It would exclude the address. What you see in a lot of cases is that where there's a monument sign, they'll have the sign area and then they'll put the address right down on whatever the base is. The address would not be subject to the sign area calculation. But so I guess the first thing, maybe the easiest thing to think about is, you know, the height and the width. Is 6 feet too low? Is it appropriate? It's clearly at a human scale. Is the width of 8 feet appropriate? With a 6 foot maximum height, that allows a 2 foot monument, 4 foot high sign, 8 feet wide. So if the commission thinks that, you know, that is a little too limiting, this would be the opportunity to start to expand that a little bit.
What were going back to your original presentation, what were the other jurisdictions using as their size?
Can you bring up your PowerPoint?
I can.
I have the one that has been proposed by the sign maker, but I don't remember the other one.
I'm reading this right. Sonoma's 32 square feet, Butte's 32 square feet, Mendocino 128, and ours is proposed 32.
Sorry.
So we're consistent with a couple of them.
As far as the monument signs.
Mm-hmm.
Let's take a look at the pictures first. Go to the pictures. So I think the 2 signs on the left, as was described before, those would comply. The 2 signs on the right, the Redwood Coast Acupuncture, that's a little higher, a little wider, a little bigger than would be allowed. The same with the sharp sign. It's 7 feet with a 12-foot width. So
would the acupuncture one not, though, be considered freestanding, since it's?
It could be. Yeah, because we don't define freestanding as only having 1 pole. So since it's not sitting on a base, a pedestal, it could technically qualify as a freestanding sign. But I think the important thing about these is that it just kind of gives you a sense of what the sign size, relative sign sizes are, and whether or not.
Yeah.
What's just kind of deceptive is these are like close-ups, and the ones on the left are a little bit farther away, so that kind of makes it seem like they're way smaller than the ones, I mean, even though they are bigger on the right. Because I think the ones on the right, especially the acupuncture, I mean, I've seen so many signs around the county that look like that, and they seem to be reasonable. I don't think there's anything wrong with any of the signs myself.
So should we, just throwing out a hypothetical, so if we say we don't see anything wrong with this, so should we say technically we're okay with monument signs going up to 7 feet high and being 12 feet wide? And so then we would have to figure out the square footage on that, if that was something we thought was okay.
I'm happy to entertain a straw poll on making an adjustment on this, if that's what Commissioner O'Neill or somebody else wants to suggest.
Or we compromise and go with the 36 and 7 and 12. That's a little smaller, but not as small as.
Mm-hmm. Yes, Commissioner West.
For me, 12 feet is a little bit high. I would be comfortable with 10 feet.
10 feet wide.
Width?
We're talking about wide.
Excuse me. Yeah, you're correct. What, can you repeat the height again then?
It's 7 feet, 12 feet wide, 7 feet tall,
Okay.
36 square feet.
You want to go with that one? Okay.
Yeah, I don't think I would be comfortable with doing the monument signs way tall if we're thinking about like people, but in this object or this picture, like the width, yeah, it could be 12 feet wide, and that's so. I mean, I would be fine with changing this for sharp, whatever that's, that would be our new monument.
Upper
sign.
limit for monument.
Yeah, so I would throw that out there as a straw poll.
Okay. Let's take a straw poll on that. All those in favor of slightly adjusting the monument sign to match that, 36 square feet per side, 7 feet, up to 7 feet in height, up to 12 feet in width. Is that clear enough for the purposes of the? Yeah. Then all those in favor say aye.
Aye.
Aye. All those opposed?
No.
No. Okay, so I believe that was a 4-1 in favor. Okay. So then, moving on to projecting and banner. Oh, yes, Commissioner Curriasi.
One quick question would staff interpret frontage along a trail, a bike trail, or an alley that was not open to vehicle traffic? Is that a frontage?
Typically not. However, there are circumstances where you've got a multi-tenant kind of facility, and maybe maybe the frontage is really a pedestrian promenade, and in that case, I would expect it would be a multi-tenant kind of building, and so it would have some kind of master sign plan. So there would be that flexibility built into that.
Okay, so then if we're moving on, and I actually think it's helpful for each of these to pull up the photo examples of this type of sign.
Great. So I have, I guess I'll go back to the photo examples, but that's the projecting and banner portion there. And going back to this. You know what? For the projecting and banner signs, we do not have examples on here. I didn't see very many projecting signs. The majority of them were wall signs. So you'll see they're I forget the name of them, but they're like box wall signs where you just put the sign into it. And I know that there are some projecting signs. Jeff Wills did provide as comment like 2 examples of projecting signs if you happen to see those.
In his photos that were attached to his comment?
Yes.
We'll try to pull those up.
Yeah.
Sure. Okay, I see that. Yeah, like Eel Valley Appliance.
Should come up in just a moment. Oh, it shared the wrong thing. I apologize. I did the new shared and went to the wrong one. But this is the projecting sign that was provided by Jeff Wills. Oh, and these are within a city jurisdiction. These are not in the county jurisdiction.
Got it. So these wouldn't be governed by this ordinance, but just as a
As an
point of
example.
reference for size. Yes, Commissioner Mulder.
Looking at this, and then I'm sitting there thinking about the sign that finally just got repaired down in Southern Humboldt, Eel River Cafe. And mental notes, I don't know if these, I don't know if the height one would fall in line, so. But, question that I asked at the beginning, if it was an existing sign, this regulation wouldn't affect it in a negative way. It could still continue operating the way it was.
That is correct.
Okay.
Is that true only if a permit was sought for it? Or, I mean, I'm still trying to get clear about what existing signs that's not true for.
So if we can stop talking about signs for a minute and talk about any structure that's built in the county.
Right.
If it's got a permit, it's a legal structure. And the same applies to signs. If it's a permitted sign and has the appropriate permits, it's a legal sign. If it happened to be there before there was a sign ordinance or a zoning ordinance, or before the ordinance was changed, whatever it is, and was built consistent with whatever was in place at the time, even if there was no regulations, then it's a legal non-conforming sign.
Yes.
So,
but if there's a building that has a building permit, but which never sought a permit for the sign as part of the building permit or at any other time, then it's not. It could have, but it didn't, for whatever reason. Then they're not protected under this ordinance.
They're not protected under the ordinance. That is true.
Doesn't mean you're going to go run around and find all the examples of that and tear them off, but it doesn't have the sort of grandfathered in quality that others do.
I think that was one of the things that we actually observed, or that going out, I didn't go out, Elizabeth and Jacob went out and looked at the signs and took pictures, is that there's a lot of signage out there that has not been permitted.
Yeah.
I have something to say.
Okay.
These types of signs add historical character.
Peggy, could you pull the mic a little closer?
Add historical character to some communities. I mean, this, to me, when I look at this, or I look at an old movie or something, and you see these projecting signs, they're part of the, character of that street. And to say, oh, too bad, we're going to rip them all down and put some modern sign up, it takes away from the historical character, and I think there needs to be an exemption for that. Some of these signs could be over 50 years old.
Yeah, we're not proposing to tear down existing signs.
Well, if they come in and they want to update it or something, and then
No. If they're maintaining the existing sign and they're like redoing the can, refinishing it, whatever, they can do all of that.
I just don't want to change the character, like you said, of Garberville, or even, we don't have any jurisdiction over downtown Eureka, but whenever you see a certain movie, a certain area, they all have those types of signs, and I would hate to see us dismantling, that character.
We're not proposing to do that. In fact, if it is, there again are two approaches here, is that the ordinance is allowing projecting signs. So those are allowed.
I'm just maybe thinking that maybe there should be some provision for historical signs that are of a certain date or time.
Well, I think there are. Those are non-conforming signs, and they're free to maintain those.
I'm just thinking that maybe they should be brought in as conforming if they have a historical character that, I don't know how that would be defined, but so that you're not changing or proposing that in the future all new signs can't be like this, because you're trying to maintain the historical character of that boulevard or that community. I don't know if I'm
So,
making any sense.
well,
but-
the thing I would also offer to you is that this ordinance does not draw sharp edges in terms of precluding things. So, again, it gets into that very squishy area of the creative signs. If somebody is wanting to recreate a historic scene with projecting signs that add to a certain ambience, trying to appeal to a certain area, you know, that can be done under the creative sign program. Or it can just outright be a conditional use permit to do that.
Or maybe they come up with your master plan for that boulevard that says, you know, you need to make sure your sign is consistent with what's already there. And so
Right.
we want you all to have those types of signs because that depicts the 1950s and we're trying to maintain that character on that boulevard.
Right.
That's where I'm going with this, is that in some cases, it may take away if we say, oh, now you have to conform to this new, you know, requirement, and we can't, you're not going to be consistent with what's already there or that aesthetic that we're trying to maintain.
Yeah, there, I think we may be seeing this from two different angles, and I don't think that we're in disagreement.
Okay, I'm just want to make sure. Because I like those signs. I think that they say 1950s. I mean,
Yeah.
they remind me of my childhood. You know, going downtown with my grandmother, and all the stores had those types of signs. And so, and I think that's one of the characters that your downtown Eureka has in
Right.
Garberville and some of the other areas.
But I think there's a number of paths for them to remain, to be updated, even to be created anew under certain circumstances with a CUP or creative sign or whatever. So take your point. But so anything more? Anyone else have comments under projecting and banner?
With hearing staff talking about the legal nonconforming and the ability of some of these older signs I'm thinking of that are in our jurisdictional areas, whereas those pictures were not in our jurisdictional
Right.
areas, I think I'm comfortable. Then I'd be fine with moving to awnings.
Commissioner West?
I share similar like concerns to Peggy, and I think that the creative sign ordinance really does address that. I think it does a really good job of talking about projecting signs and creative materials. So that's where I'm comfortable with that answer. And additionally, the sizing that we have in the table, because if you want to do something a little bit different than that, you can look at another avenue. So yes, I'm
Yeah.
ready to move on.
Okay. Yeah, and I'm realize that, you know, we're going pretty slowly through this, and this is an important and dense section, but hoping we can keep moving so that we can actually get through this whole thing tonight. Awning. Does anybody have comments on the awning section? And I don't recall if you had any pictures of that, but
I did not.
did not, okay. Does anybody wish to discuss the awning sign section? Yeah, okay. I'm fine with that too, so then let's move on to the wall sign section where there are alternatives to discuss.
Right, so in the wall sign section, we have two alternatives. The alternative to the difference there is the area. So that would be, instead of 1 square foot per linear foot of the facade, it would be 2 square feet per linear foot of the facade. So if you would like, I can pull up the presentation pictures.
Yeah, I think that would be helpful for this one. Thank
Okay.
you.
Oh, is it not sharing it? It should come up now. There we go.
Yes, Commissioner West.
Was there more staff wanted to say?
Oh, or
Sorry, this is based on the 1 square foot per linear foot, just as a.
okay, right. When you say the eligible, that's measuring
based
the
on-
width. 40 feet means they're eligible to have 40 square feet. Okay. Did you have a, Commissioner West, did you have a question or comment, or?
Sure. I think I'm comfortable with the 1 square foot, although I think wall signs are a kind of sign that tends to blend a little bit better into the view shed than other kinds of signs. So I think this is one area that if there was feeling that we should go a little bit bigger, I could be in support of that also.
So did you say all these are conforming?
These are all conforming. Sorry, except for A&L feed. McKinleyville Ace and State Farm are in conformance. And something else that I had shown was Six Rivers Brewery that had multiple wall signs. And so that's something to consider when it came to the quantity of the wall signs. If it would be based on quantity per sign or if it would be based on just the overall square footage. That could be maybe split between signs.
Right.
Could I just throw one other thing in? When you're looking at ACE, if you're familiar with McKinleyville, I know Commissioner O'Neill, you are, is that they've got a very similar sign to this around on the entrance to the building. And this is one sign per facade. So they can repeat that sign around on the front, which they have.
All 4 sides if they wanted to.
Yes.
Right, per facade. Yes, Commissioner Mulder.
So I go back to that A&L feed, and I'm looking at I kind of think that more square footage for wall signs, for putting the sign about your business on your building. I think we should have a little more flexibility there. That's just my personal feelings. I could be alone in that, but looking at a functional business and the signage doesn't seem overwhelming to me. I would like to try to lean towards setting a square footage that would make that conforming.
Isn't that 2 buildings? It doesn't matter.
I was going to try to debate that point, but I didn't want to go there.
Yeah, I mean, I tend to agree with that, and I think that's kind of what Commissioner West was saying as well. I will say that I do think allowing, whichever of these sort of square foot limitations we settle on, I think allowing them to split it makes sense. I don't see a downside to that, and could be helpful. So that's, strictly speaking, not how either of these alternatives is phrased. Do you have your hand up? Commissioner West.
I just wanted to clarify, when you mean split it, you mean that take the square footage in aggregate and it can be over multiple signs
On that facade,
Yeah.
yes. That's what I mean by split it,
Great,
right,
okay.
yeah.
I am also in support of that.
Okay.
And through the chair, if
Yes.
I might, that would be something we could clarify as easy as saying not specified for quantity, and it would be focused on the area. And something that was brought up at the last hearing, just to point out, was the addition of not exceeding the 100 square feet. I know Commissioner Skavdal mentioned that, and that was something that we added because of that. So,
right.
So when taking into consideration maybe alternative 2, there would still be that limit of 100 square feet.
Right, in which case, yes, so even the A&L, if we were to choose alternative 2 as drafted, that would still be out of compliance with it.
That is correct.
That's what I was trying to say, the square footage part.
Yeah.
I'm trying to remember. I remember listening to that comment.
And to clarify, this is 100 square feet in aggregate across all facades.
No, I think it's per facade.
Okay. I think maybe I would recommend adding that for clarity.
Mm-hmm. Okay, yeah, sure. Well, so should we can either choose one or the other of these alternatives, or potentially suggest, I guess I have already suggested that we make a change by allowing the aggregate square foot to be divided on a facade between multiple signs. So, does somebody want to propose a vote on one or the other of these?
So
Commissioner Mulder?
back to that A&L. So could someone? I just want to ask a clarifying question.
Oh, you want to go back to the photo of it?
The photo of
Yeah.
it, because could you claim that there's more than one facade there? So then you would be allowed more than 100 square feet, because there's this
Yeah.
side and this side.
Technically, there are two facades there. Technically, there is a south and an east facade.
Okay, so if that was the case, then I would be good with the language that you were talking about of the aggregate doesn't go over 100 square feet per facade,
yeah.
because that would make that conforming legally.
I think,
But you also have different purposes, like if you go to a building and this is where the feed is and this is where the main store is, how do you differentiate between the two? Like this is where lumber is and this is where, nursery is. Don't they get to do that?
Well, oftentimes within the development, yes, they get to sign things. This is really signage that that is locating the business out on the street. So, like within the store, or like a lot of times, you mentioned like a lumber yard, and you go out there and you'll see treated lumber or Doug fir or redwood, and within the yard, that's fine.
No, I'm talking about going into different sections or different buildings. They should each be able to, label themselves without it taking away square footage or something.
Well, if it's signage that's oriented towards the street, frankly, that's part of the signs.
Like if you say you go to Pearson Lumber
Uh-huh.
and one building's the nursery side, one's the hardware store, and then you've got the lumber yard. Couldn't they have a sign for each area?
Well, but Pearson's, that's what I'm trying to say. Once you drive into the driveway and you're within the campus, that's not oriented
These
to
don't
the street
apply.
anymore.
But two of them, at least the nursery one, is facing
Yep,
the.
that's part of the street oriented signage.
so just to be clear about what you're saying, and from that example, the edges of the Pearson buildings that actually are facing the main drag, those would be governed by this, but the interior of it would not be governed by this. Okay.
If that building was in jurisdictional
Well,
area.
exactly.
Just wanted to point that part out.
Yeah, I'm just using.
Sure,
it as an
sure.
example. Yeah, the other place.
So I want to make one thing clear. One of that you're talking about here is if you stay with 101 square foot per foot of facade, up to 100 square feet, for each facade, that's 400 square feet of signage on a building.
And usually cost is gonna govern a lot of this. I mean, you
Right.
have a budget for signs. You don't have an unlimited amount of money for signs.
Yes, Commissioner West.
I don't want to cut off questions, but I do want to propose that when I would like to propose a vote at some point for alternative 2, but removing the quantity cap.
I would be really happy to move to that if we're ready for that. Yep. So alternative 2, removing the quantity cap, which simply means that aggregate could be split between multiple signs per facade. Everybody clear? All in favor of that, please say aye.
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 Aye. All opposed? So that was unanimous? Okay. Unanimous in support of alternative 2 with the quantity removed. And perhaps to Commissioner Curriasi's point, just clarifying that, what was it that you said that might be clarified?
Yeah, I pondered proposing that it's per facade, per frontage, or facade, I'm assuming that's what you're getting at, is facades that are on a frontage, or how the word frontage has been used.
Yeah, I think that would be helpful. I think that's what we're intending, but that would probably make it a little clearer. If you're okay with that, Mr. Dunn? Great.
Do you understand what that means?
Yeah, I could either put it as per facade, 100 square feet per facade, or it could be 100 square feet per frontage.
No,
Facade front.
yeah.
Because those are two different things.
There are two different things. So, and frontage is typically a street frontage. So are we limiting it to a facade that has a street frontage?
That would be my interpretation of it. So where if the building has 4 sides and one side is facing a street, then facade only applies to that street side.
So,
Well-
that would preclude that ACE sign above the main entryway.
Yeah,
And that would also preclude, like, Mountain Mites Pizza in, well, that does have a sign program that they haven't really complied with, but that would preclude, that would allow the signage on the back of the building, but not on the portion of the building facing the parking lot.
Is, in the McKinleyville Ace example, so that street, so that's a private road then?
Yeah,
I see.
yeah,
So that would not be considered a frontage?
correct.
Okay.
yeah, I did not think we were limiting it to just the facade that is on a road frontage.
That was my thought of the vote as well.
Okay. All right, so we'll stick with the vote we had. Okay, window signs. Yeah, and we don't, if people are basically, yeah, great, you have the examples already up. What's stated here, just to be clear, is it's not alternatives, but it's a little bit changed from last time.
Slightly, yes. So we removed the quantity portion to say not
Right,
applicable.
right.
And we had it based on per facade. And there was a design feature that's allowed now with the neon or other small diameter tubing eliminated by fluorescent gas. And then a height limit due to businesses or buildings that may have 20-foot, 30-foot high window walls. And that would, allow daylighting into the building still.
Sure.
And reduce the impacts of visibility.
I'm comfortable with this. How do others feel? Yeah. I think 25% seems reasonable. I do appreciate allowing the neon signage as part of that, so.
Does, like during the holidays when they spray paint them with snow and all that, that doesn't count?
That would be a mural, I
That'd be
believe is
okay?
how we're,
That's a temporary, seasonal kind of thing.
yeah.
Maybe we should just exempt seasonal displays in terms of windows.
Yeah. Otherwise, we're like the Grinch that stole business's Christmas.
So is that a straw vote to add exemptions for seasonal decorations?
Sure, let's take a straw poll on that.
Yeah, decorations.
All in favor of exempting
Those
seasonal
aren't signs, they're
decorations?
decorations, yeah.
Say aye.
Aye.
Aye. Any opposed? Okay, so yes, we can make that change, and otherwise, we're comfortable with the window section. All right.
So moving down to A-frame, standing, and this was another window sign section there, but we'll move down to A-frame, standing, and feather banner signs. And the thing that had been added here was the feather banners, and nothing has changed in the A-frame and standing sign section.
So this would mean feather banners can count as an A-frame and standing, and you could have up to 2 per business.
That is correct.
And in the case of the feather banners, they can be 30 square feet, et cetera, whereas the A-frame and standing have smaller limitations, size limitations.
Yes.
Okay.
Is it either or both? Can you have both banners and,
You can have one and the other, yes. You could do an A-frame and a feather, or you could do a standing and a feather, or you could do two feathers.
all right.
Mm-hmm. Yes, Commissioner West?
Just real quick, I really like the compromise that staff found with this one based off of our feedback last time, so thank you.
Oh, yes, Commissioner Kiriazi?
I think this is maybe another example where, I fully support or obstruct ADA access, but again, I'm assuming we don't want to obstruct the flow of people. I don't know if we necessarily need to specify that, or if we are going to specify it, then I feel like there's a broader number of situations where we want to specify, or perhaps ADA regulation requires us to.
Yeah, I see your point.
Well, sorry.
No,
Through
go
the
ahead.
chair. Yeah, so the placement of it in terms of the county right-of-way and ADA access is a public works requirement. So that was added in there for that purpose as well.
I mean, I think if I'm understanding Commissioner Kiriazi, though, you're suggesting that maybe we want to say or obstruct ADA access or the flow of pedestrians and bicycles or something like that. I mean, not just ADA. I mean, we don't want to obstruct anyone's, the free flow of pedestrians, et cetera.
I'm assuming the county right-of-way would include a bike trail, like you couldn't put it in a bike trail.
That is correct.
Okay. But yeah, it still seems like, I just was caught by that.
Yeah. Did you have your hand up?
I just want to clarify the way I read this is the county right away, or that would be the flow of traffic, like people, traffic, bikes, walking,
Sidewalks.
any of those type of things. So in my mind, the way I read this, I thought it was taken care of. The only thing I would note is I've never noticed feather banners the way that I've noticed them since.
Oh, yeah.
You guys talk about them.
Right.
In January and December.
There's a lot of them around.
There's, oh God, in Eureka. Whew. Holy cow. In the highway, actually.
Totally. Yeah, so I mean, Director Ford, we don't need to make changes if that's really understood, that the county right-of-way would include sidewalks, bike lanes, thus we don't really need to specify don't obstruct pedestrian access, do we? I mean, does that add anything?
Well, I think one of the things there that is an overriding, there's two things that are very strong there. One is obviously county right-of-way, and two is ADA access. So there needs to be complete open path of travel within a site outside of the county right-of-way.
Yes.
For there to be pedestrian connectivity.
Right.
There has to be that path of travel. So it can't obstruct path of travel.
Yeah. So I guess it sounds like this is pretty strong as it is. I mean,
Does those ones that they blow up and they come down, are those under the feather banner category, or?
We're not envisioning those.
We can have those without?
They're not really allowed unless you want to get a creative sign permit.
No, I'm just wondering where they fall within this ordinance.
I would say that would have to fall under some kind of creative sign.
Okay, so they're just excluded unless
Yeah.
they're permitted.
If you have to name them, their technical term is wacky, wavy, arm flailing, inflatable tube bin.
Technically. Okay.
Chair, could I have a go back?
Yeah.
Back to wall signs.
Okay.
We have identified that it'd be a maximum depth of 7 inches. And I do recall that there were comments that it needed to be a little deeper than that.
Mm-hmm.
And I just don't want that to become a hang-up.
It was 18 inches in the recommendation of the sign.
18 inches is the recommended, and there is a consistency with that in, at least in Mendocino. That is consistent with Mendocino's ordinance.
Up to 18-inch depth
Yes.
is what Mendocino allows.
Yes.
I'd be good with that.
I'm fine with that, I think. Any objection to making that adjustment?
No.
Okay, then sure.
Okay.
Yes, Commissioner West.
To talk about the wacky wavy men, they're inflatable, right? They have a blower.
Mhm.
Wouldn't they then fall under decorative signs, under prohibited signs?
Yeah. I
So
guess
there's-
they could, yeah.
And I will get to that later, but I think we do still have feather banners under decorative signs and prohibited signs. But right now, decorative signs reads banner signs, feather signs, yard signs, and inflatable signs, except when used as temporary signs.
Sorry, where are you seeing that?
If you go to prohibited signs, I believe it's section 4, decorative signs.
Oh, that, now I see. Yes, you're absolutely right. Okay. So we'll get to that, but good catch. Okay. So, basically then if everybody's okay with the A-frame standing and feather banners, then, yeah, then we'll move on to fuel price signs, which was just, I for some reason thought that was like state law made that, superseded our authority on that or something, but these limitations are consistent with state law?
I did check with like standard throughout the state, and it should be consistent with state law, yes. And I decided to add it in here just to further specify it because we had a colleague, another planner, who pointed out that illuminated fuel price signs, if you read through and you don't know until you get to prohibited sign section that fuel price signs are allowed to have illumination.
Right.
And so in order to clarify that is allowed,
Sure.
I decided to include that into, or we decided to include that into the pertinent table.
And they can have digital
We just have to
numbers.
add the illumination portion.
They can have digital numbers that can be
Yes.
electronically changed.
That was the goal.
Yeah.
It did not get added into this, though.
And one of the things I think we need to do there, though, is somehow describe that differently than digital.
Yeah, I don't know.
Because we don't want to say that they're getting a privilege that is prohibited in all other signs.
Right.
So it's probably going to,
Could be changeable number.
Or you
I
could
don't-
probably go to the industry to get them turned.
yeah, we'll just use some appropriate terminology there, but I just want the
Yeah.
It's
planning
just really
commission to be
important
aware.
that is, because commodities, they change like
Right.
Right.
daily.
I think we all understand those need to be changeable, and it's practical to use LED or whatever the illumination is for that, so. Okay. Yes, Commissioner Curriasi.
So I guess one thought I had is, are fuel price signs with these requirements allowed anywhere? And my thinking is that this design is specifically, again, for that highway application where you have high-speed driving, you can see them from far away. So are we allowing this in a downtown center?
Yes, I believe it would be for any location that has been approved to be a gas station.
Commercial or industrial zone.
Yeah.
Mm-hmm.
I guess I'm sort of inclined to, I don't know if we're allowed to, but kind of propose that they're allowed to be 128, they're allowed to be 24 feet tall within proximity of a roadway above a certain speed limit. It just seems odd to me that we're allowing signs this tall for specifically gasoline stations, but not for other businesses for freestanding or monument.
I don't know that we have to allow it to be that tall. We just have to allow them and allow them to be of a sufficient size to be readable. And so those are the issues that we confront there.
So could you say a certain height, and then if they want to be higher than that because they are on, you know, a different stretch of highway, that they would come in for a special permit?
Yes, but I'm gonna say that I don't know if the state has a height minimum. They probably have a size.
They definitely characterize the sizing for each number, so the number heights and the letter heights and the gasoline type. And so they specify those things. They do specify just the lettering. And when looking at that, I took that into consideration of also wanting to raise that sign, because you have to they also require the allowance of the emblem, so the advertising of the business itself, to be included in that space as well. So putting all those numbers together and giving them the allowance that would be required by state law, plus what is typically seen, at least from most of the businesses that or most of the gas stations that we've seen around, it seems that 20 to 24 feet seems about the height that you might find on the regular.
Yes, Commissioner Curriasi.
When you say the state allows for all of those elements, does it require all of those elements?
Yeah, it requires that each number height is given a certain amount of space.
I guess you had also mentioned the business emblem.
Yeah, and the place of business is supposed to have a specific amount of space as well. I don't know them off the top of my head, though.
So if you're, say the gas station that's at Murray and 101, that's along the 101 highway, that's pretty high because you want people driving down the highway to see it. Now if
Right.
you're going down Henderson and, you know, and you see a lower profile because the speed limit is lower, I can see that there could be a different,
Yeah, I guess my thought was to propose the same height limit that we agree on for freestanding, if that's allowed within state law.
except for I think if they're along the main 101 highway, they should be able to have a higher sign.
But along the highway, under the ordinance, they can still apply for a
variance.
conditional use permit to get whatever height they want to get. And ironically, the 76 station that you're speaking to has a very tall 76 logo up in the air.
Right.
But the price sign is down at the level of the gas
I
station.
was thinking of the logo, and is that different than this one? Is it-
Well, what this is doing is allowing the gas price sign and the logo to be incorporated in the same sign. So I think one of the things that we've done here is try to provide clearance. And so it could be that if the commission is of the mindset to allow this sign to be of the same basic height as the other freestanding signs, that it just would not have a clearance. It may end up being closer to a monument sign.
And so the 128 square feet, that is, you came up with that from those state requirements?
That's based on taking away the clearance, which would leave you with 16 feet in height for the advertising display itself, and 8 feet wide would give you 128 square feet.
Did you calculate the height of the letters, or did you just use other typical cans that are around?
I used other typical plans. So I have a shared screen with the Chevron that's located in McKinleyville off Central Avenue. And that one is within this requirement, or within the allowance.
And that's a typical gas. I
Mm-hmm.
don't know about that thing hanging on the side.
I'm good with 24 feet and ready to start talking about freestanding signs.
Yeah. Others? Are we good with this? Do we want to conceivably reduce the fuel price height if we can?
What if they have, like in that case they have multiple businesses within the business, like sometimes they have a food vendor inside, like.
That's what you see on the Chevron station right there.
Right.
They
So
have
is that
Aztec, they
included
have the
in
coffee shop.
The square footage?
It would be, but if there's multiple businesses on site, they would be getting a master sign plan.
Okay.
Commissioner West?
So, Commissioner Kwarzi, are you proposing a straw poll to reduce the height?
I think so if staff feels like that would be possible, given state requirements.
It depends. I mean, I'd have to really track down what the state requirements are for the minimum height. I just don't know the minimum.
I think just to clarify where I'm coming from, it just feels odd to call out a special privilege for this very particular business type. That's really where I'm coming from.
Okay. So it sounds like we could have a straw poll on that with the caveat that we won't change it in a way that violates state law. But with that said, Commissioner Kiriazi is proposing that one, basically you're proposing to change the height, reduce the height max to 14? Or
Could I offer a suggestion?
Yeah, okay.
Since the reference was made to make it the same height as the freestanding, maybe you should settle on the height of the freestanding first.
Fair.
And then go back and revisit this.
Okay. That's actually very practical. Okay, so we'll table that for the moment, but let's get to the freestanding then.
And if you want me to flip through these to the other images and as well as the comparisons with other jurisdictions, just let me know.
So that's Murphy's 24 feet, correct?
Yes, and these are estimates based on calculations that I did using a couple different programs.
So I would ask for a straw poll to adjust the height on freestanding to 24 feet.
I just don't think if you look at the stars and that's 13 feet, you add one more foot to that, you're not going to get all the fuel stuff on that sign. The information that you
That's why I'm talking about the Murphy's sign right there. And that's why I'm asking for a straw poll to bump it up to 24 feet for height on freestanding signs.
Okay, we can have a straw poll. I mean, anybody want to get a word in before we take a vote?
Yes,
Okay.
Just a quick one.
Okay, yes, Commissioner West?
Yeah, I think for me personally, freestanding signs are the most distracting in the view shed, so I'm going to lean pretty conservative on the height on freestanding signs.
Okay. So we have a motion, or not a motion, but straw poll request to make this freestanding height limit 24 feet. All in favor, say aye.
Aye.
All opposed, say no.
No.
No. Okay. Maybe something in between. I'm not wedded to the 14 feet max. Personally, I would be open to entertaining something that's a little bit higher than that. But I don't know if anybody else
You
is.
guys talked a lot about that E&F sign, the 20-footer.
Mm-hmm.
A lot.
Mm-hmm. That's true. Well, is there any appetite among the rest of you? Obviously, Commissioner Mulder wants a higher height limit. And I'm open to that, but what are the rest of your
Can
thoughts?
we look at the other jurisdictions again? Okay, so 20 would be a good compromise.
I'll propose 18 feet.
For all, that would be gas station and?
Go ahead.
Well, I think that we would be discussing gas station after this, but we, arguably, yes, if we pick a freestanding height and then we match the gas station height to it.
Okay, so straw poll on raising the height of freestanding to 18 feet. All in favor, say aye.
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 All opposed?
No.
Okay, so that one passes 4-1. Okay.
Perhaps before you finish with freestanding signs,
Yes.
you should think about area.
Right. Well, we also have to decide, I mean, we're sort of, it seems that we're almost assuming that we're not going to choose alternative one, but I shouldn't make that assumption because that is put here as one alternative is that all freestanding signs in any zone would require a special permit. Alternative 2 is the one that specifies the size and height and so forth. Seems implicit in the straw poll that we're choosing alternative 2 or a version of alternative 2, if that makes sense. But
I just think that if you have a sign that's 18 feet tall, it's got 2 poles, that you should be able to use a certain percentage of that. You know, you don't want just 2 poles up in the air with a little sign on top, so maybe it's a percentage of that that could be used for signage. Does that sound reasonable?
As a recommendation, you may think about how wide you'd want it then to be able to allow for space on the outsides of where the sign area is or the advertising area is.
Yeah. So you don't just have 2 giant poles in the air and your little sign up on
Right.
top. You wouldn't want maybe 75% of that or.
Well, so
more.
for instance, if you allowed an 18-foot tall sign, and you stayed with the recommendation in alternative 2, which is to have it 8 feet wide, and then you allowed an 8-foot height of the sign face, that would be a 64 square foot sign.
Okay.
Commissioner Mulder?
And that would be in line with Mendocino, Butte County, as far as the square footage.
Yeah, that's true.
So I'd be good with alternative 2 with the 18 feet height. Technically, that's already been voted in, and 64 square feet in area.
Okay, well, let's take a quick straw poll on that. We've already voted to make it 18. All in favor of allowing up to 64 square feet for the area of a freestanding, please say aye.
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 All opposed?
No.
Okay, so a different 4-1. But
And that was, just to clarify, that was accept the rest of alternative 2 as well.
yes, and with the other specific specifications of alternative 2. I think that was what was intended, so yes. Okay, yes. Should we turn back to fuel price signs? Given that we've decided to make the limit for freestanding 18 square feet, if it is not inconsistent with state law, how about a straw poll on making gas station signs also limited to 18 feet of height?
As long as they're
Oh,
functional.
yes, Commissioner Curiazzi.
Can I revise that
Okay.
straw poll to, if again, it's consistent with state law and it's feasible, that they're not regulated any different than freestanding?
They just have to be functional, and the functionality is the different types of fuel, the prices, and you've got to be able to see them. So I wouldn't want to like put them under the same requirement because they're not the same. And therefore, people driving down the road who may not necessarily be familiar with your community and know, you know, to stop there because it fuel's this price or that price. So I think it needs to be functional and consistent with the industry standards and not us get these miniature little numbers that no one can read.
I guess, I think we can't change state law, but there's many other ways to make communicate information functionally within a freestanding sign. However, I think this particular industry is governed under particular state regulations, so they're treated separately, so we're bound by that.
And you don't want to force, if the industry makes a sign that's this big, that's what, and then all of a sudden we have an ordinance that makes you, oh, that's a specialty sign, that's going to cost you 3 times as much because we typically make them this size, then I think we need to not deviate from what is out there.
Okay, yeah, I think it's one thing to propose lowering the maximum height. I would be personally comfortable with that, but less comfortable with the area. Making that as small as all other freestanding signs, simply because of what we were shown about. It has to have this, and the numbers have to be this big. I mean, that's my personal take. But you can propose whichever. You can propose a straw poll however you would like.
Yeah, I mean, I think the price of food is just as important as the price of gasoline. So I think Murphy's also should be able to present the price of their products on their freestanding sign if they choose. So again, I feel like that this is more of us being bound by the state requirements rather than, I just don't understand a reason why we have to treat this particular business differently.
Okay, yes, Commissioner Mulder?
Just looking in that, look at the price, like the price area, I would be willing to, that's every bit of 40 square feet, maybe more, just in that legal requirement part, so.
Just in the price area.
Just the price area, and that, from what I heard from staff testimony, that is the height of the numbers is a requirement, so.
Let's have a straw poll on something.
I'll do a straw poll on regulating fuel price signs exactly the same as freestanding.
Okay. All in favor say aye.
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 All opposed say no.
No.
No. Okay. No. Sorry. Yeah. I'm a no on that, just because I don't think that's practical, feasible, given what we think we know about the requirements. I would be open to something that proposed a height limit of 18. Yes, Commissioner Curious.
I think there's an unknown here about exactly what the
Right.
minimum height is required. I'm not excited to put this back to staff. I understand what this could present, but there is an unknown here.
Yeah.
So I don't know if even choosing 18 feet is going to give staff the height necessary to meet state requirement.
Then you could maybe word it as 18 or what is required by state law.
That's
And
fine.
then give you the option of putting in the state requirement. And if you had to order the box that lights up the numbers and they make it in a certain size, that's what you're going to order. You're not going to say, well, I need 1/2 that size. And then they're going to, well, we don't make those.
Right.
It's going to cost you a lot of money
Yeah.
to get a smaller version just because we made an ordinance that doesn't make sense.
For the sign area
Yeah,
itself. That's my feeling.
The guts that
Yeah.
are lighting up,
Right.
they're kind of come in standard sizes.
Could I ask, could we take a 5-minute break and let me talk to Jacob for a few minutes?
Okay.
Because I need to get some clarification on this.
Okay. We could. No, I don't think I want to go there. Okay, because I just feel like that's opening a can of worms. 5-minute recess, yeah. We can get. So you guys, Director, what did you learn?
I think that we looked at the minimum. What we tried to do was model it after basically that chevron sign that you saw there. And that's much bigger than the minimums that are required. We feel confident we could fit it within the area of the existing freestanding sign. I've got a picture here I'm trying to get from my phone onto my computer that I can't show it to you unless I can do that. That is basically a monument sign. That would be, that would fit within the framework of a monument sign. So these things don't have to be huge. It really does come down to location. I think Commissioner O'Neill is really right about that. On a high-speed roadway, you probably want a little bigger signs. But when you get on a road similar to maybe Myrtle or even Central, you don't really need signage that big. The speed limit's not that high.
Okay, so you're saying, if I understand you, that as you think it would be consistent with state law as you understand it, if we were to actually set it, as Commissioner Curriasi suggested, at the same size as freestanding signs?
Yes.
Which we are limited to, which we made 18 feet high and 64 feet of area.
64 square feet.
Yeah. I mean, we did have that as a straw poll, but maybe this is new information, so.
If you find out something different, then you can let us know.
Yeah. Okay, so, yeah.
Okay, so then I guess the question is for those of you who voted, but does that change anybody's vote in this? Does that make you change your mind on the straw poll, or should we just move on?
No, we did. We did, and Thomas and I, you and Thomas and I were no, and Sarah and Jerome were yes. But that is because I thought, as a practical matter, that it would conflict with the required size. The area was the thing I was. Yes.
So if someone had a gas station and they wanted to get a sign that was 24 feet tall, they would have to get a conditional use permit?
That would be correct, yes.
Yep.
Okay, then my vote doesn't change.
Yeah. All right, well, let's, in light of this new information, let's just have that straw vote to make the fuel limitations the same as other freestanding signs. All in favor, say aye.
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 Aye. All opposed?
Oppose?
No. Okay, so,
If I may, through the chair,
yes.
something to add to that was the illumination allowance for fuel price signs.
Yes, which you mentioned earlier should have been added, right? So yes. Yeah, okay. Okay, thank you. All right, so we think we're done with the table then?
We are. Moving on would be the master sign plan.
Which has not changed since the last iteration, right?
It has not.
But doesn't mean that people certainly can have questions, comments, or suggest changes. How do people feel about the master sign plan as written? Yep. Yes, Commissioner Curriasi.
Just a clarifying question, are these allowed for multi-dwelling units, residential, large residential?
Large residential would require a conditional use permit for a sign.
Okay, I think I'm happy with it as it is. If nobody else has questions or comments, then we can move on.
Great. So next section here is murals, which has also not changed since the last text.
Yep, I'm happy with this section. Other comments, questions? Good? I see thumbs up on this. Okay.
Great.
Then creative signs?
Next section is creative signs. So there's a couple different things particular to creative signs. So you have just the main section language itself, and then you have the review, which would go to the zoning administrator, and which also could require modifications if the zoning administrator believes they're necessary. And then past review, we have the permit required for it would be with a special permit. And as part of the design standards, they would need to meet all of the general design standards and have at least 3 or more of the sign features, materials, and contextual criteria provided in part 2. And something that I had mentioned during the presentation was consideration of natural features, something similar to Miller Farms, that could be added in as a part of the sign features, materials, and contextual criteria.
Everybody happy with this?
With that addition
Yeah.
that's mentioned?
That's what I was going to say, yep.
Yes. Yes, Commissioner West.
Just a clarification, so that would maybe fall under materials that you would be adding, like natural materials, I guess would be the way you would phrase that?
Yeah, maybe natural features.
Okay. I'm good with that.
Okay. All right, then with that small modification, I think we're good with that section 2, and now we get on to existing billboards.
Right. So with existing billboards, we have the first section here. Basically, defining existing billboards as an advertising display affixed to any post within 660 feet of a state highway, freeway, or historic highway or freeway that was lawfully erected in compliance with state laws and local ordinances in effect at the time of its erection. So that's also to help account for the billboards that you might see on Myrtle Avenue, where there was a historic highway there, and there are still billboards that exist there that were legally erected at the time. Moving to section 2 is the failure to provide active and compliant outdoor advertising permit when that permit is required by state law. Shows evidence that the structure doesn't qualify as an existing billboards, which may result in removal. And any questions so far regarding those? Nope. So next section here is defining placement. So something we faced with existing billboards was that the state has a lot of laws in place to define what is allowed or what a local jurisdiction is allowed to regulate versus not. And the thing that local jurisdictions are allowed to regulate is placement. And so what we've done here is defined placement, and we included, there was a portion, section I, that had initially just said re-erection of an advertising display. And so we've further expanded on that for specifically for re-erection of destroyed advertising displays, and so that the existing billboards, as part of the general plan, there is guidance to basically allow new and existing billboards, although with new billboards, there's also general plan guidance that says any eligible scenic highway within the county's jurisdiction is to be treated as a designated scenic highway, and part of the general plan's guiding policies is that new billboards should not be placed on designated scenic highways. So which is why new billboards is included as prohibited. And we've allowed the continuance of existing billboards if they do get destroyed due to natural forces, and that's where section 2 comes into play. And to also follow the guidance of the general plan states protection of natural resources and also scenic views, and also requires that a conditional use permit with a term limit of 15 years is issued for new and existing, if feasible. So in this instance where there is an advertising display that is destroyed due to natural forces and it's not located in any of these locations that are sensitive, then they may reconstruct it with a conditional use permit and will be limited to a term of 15 years and have to receive a building permit to reconstruct that billboard. And part of the general plan guidance also states that reconstruction of billboards should not be limited if it's due to vandalism, and that means that the billboard should not lose its legal non-conforming status as well. And so we've added those sections to really clarify what the general plan guidance is and how we're trying to regulate it.
Okay. Yes, Commissioner West.
So we've covered natural forces and vandalism. The only other thing I could think of that would happen to a billboard is a car hits it. Where does that fall into damage? Does that fall into natural forces? Does that fall into vandalism?
I don't have a great answer for that. I would say that is somewhat accidental and could be considered vandalized, I suppose. Someone could purposely drive their car into a billboard if they chose to.
But just to be clear, those two circumstances, natural forces or vandalism, they're both treated the same. Is that correct? Or maybe not identically? They're both allowed to be rebuilt, at least if it is, in the case of the natural forces, if it's not in a body of water or something like that.
Yeah.
But vandalism, they can rebuild it no matter where it is in the event of vandalism, because we don't want to incentivize vandalism, basically.
That's correct.
Okay, so they're not treated exactly the same. Yeah, thank you. Commissioner Mulder, yeah.
Clarifying question, in regards to how is vandalism determined? So say we have a huge windstorm and it's in a body of water and someone may have done something to go jeopardize the structural integrity. Is it on the applicant to prove that to the county, or how would that work out?
Yeah, it would need to be demonstrated that there was some act of vandalism there.
Okay.
Back to the example of an airplane flying into the sign or a car hitting the sign. We can add under the natural forces or other accidents that may come about to address that if that's what the commission wants. We were just trying to think through what are the normal causes that cause a billboard to fall.
I would be okay with that. You asked the question, would you support?
I would support adding it to the natural forces section, but I think Commissioner Mulder might have a relevant comment.
So on the opposite of that, I'm not saying that anyone would drive a car through a billboard, and I know there's some billboards in bodies of water that some people really don't like, and they're entitled to that. I would like to lean any man-made object that is going to potentially destroy a billboard to be under the guise of vandalism rather than a natural force. That's just kind of where I'm coming from.
I'm confused about the 15 years. Does that mean after 15 years they have to tear it down, or they get it re-permitted? What's going on there?
After 15 years, it gets removed. So what both the Outdoor Advertising Act and the general plan call for is an amortization period, meaning that, yep.
Okay, so you're suggesting that the reference to cars and other accidents should be added to the vandalism provision.
Yes, because I don't feel it's a natural cause, because it was a human-made device that destroyed the billboard.
Yes, Commissioner West.
I think for me, it comes down to intentionality, which would be determined in the investigation. And if it was vandalism, then the owner of the billboard would have the investigation to point to as evidence that it was vandalism versus an accident, and therefore a natural cause.
I agree with you 100% now, so I'd be good with adding it the other way. That's like splitting hairs
Yeah.
right there.
Okay. Okay, then should we have a straw poll on Commissioner West's suggestion to add reference to car or other accidental causes? Yeah, yeah. So all in favor of making that change, say aye.
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 Any opposed? No, okay, good. Yeah, and just in general about this section, it does feel that you've tracked down thoroughly how far we can go to prevent the replacement of or new placement of billboards. I mean, basically, there seemed to be still a little bit of question when we had our last meeting about what we could or couldn't do under the state law. You now feel like you've got that pretty like dialed in.
And I would say thank you, council, for the guidance on that. That
Okay.
has been extremely helpful.
Thanks. Yeah, thank you, council. Yes, Commissioner Curriasi.
A question, I'm curious if there'd be interest in, on Part 2C, changing the wording of the term limit to not to exceed 15 years? Or instead of immediately granting 15 years?
Commissioner West?
I'm in support of that. If staff, I think staff has done a lot of work on trying to navigate state law, so I don't want to put a wrench in that. But if it doesn't put a wrench in that, I'm supportive of it.
It doesn't put a wrench in state law. 15 years was identified in the general plan. I don't know that the Outdoor Advertising Act has that time frame in it. It really, the time frame has to be that there be a time to recoup the cost of the billboard in terms of making the investment. 15 years is conservative. So that's fine.
And you don't want to like do a Fifth Amendment taking where you're, devaluing someone's property that they've paid for. Like, the individual said they invested in this business so many millions of dollars, and now you go, oh, you can only have it for the next 2 years, and they don't recoup their investment. Then do they have a suit against the county for creating a financial hardship?
Well, I don't think so, because what we're essentially doing up front is saying here is the conditions under which the billboard can be reconstructed. And so if you want to reconstruct it under these conditions, you can.
Okay. But they've already recouped their initial investment?
The investment of the existing billboard, they have been receiving the benefit of that up until the point in time when the billboard came down.
So you seem to be saying that if we were to make the change that Commissioner Curriasi suggests, a term limit not to exceed 15 years, you think that's still consistent with our general plan?
Our general plan identifies 15 years, so.
Yeah, okay.
I think we should stay consistent with the general plan.
Yeah, I think that's probably the way I would go too. I do want to wait, so no straw poll needed on this then? Okay, sure. But I want to mention Jeff Will's point about that same provision. And if I understood him, he was saying that in the event of like a damage or loss of a billboard, under the ODA, you're mandated to replace it within 60 days, I think, to preserve your rights. And he noted that a conditional use permit could often take longer than that. So that seems like a valid concern for him to raise. Thoughts about how that could be, rectified or made consistent?
What's that? I think we need to do a little bit more research on that, because I think that there are timeframes that can be extended even under the ODA, especially if the county's taking time to re-permit it. Okay. And if he's, taken those steps, I would hope that the state would understand that and not revoke the state permit.
Mhm. Okay, so you would not recommend making any change at this time?
Not at this time, but what the commission may want to do is recommend to the board that they receive a report from us what the ODA requirements are, so that they can consider that as part of their final action.
Specifically with regard to timing?
Correct.
Yeah. That, I would suggest we do that then, if you're comfortable with that?
I think that'd be great to add in our.
Yeah?
Yeah, and I do appreciate the chair recognizing that comment and recalling it. I think it was an important comment.
Sure, thank you. Okay, Sarah's not thrilled with it, but you're not going to block it, I take it. Okay. All right, then, any other comments about, I mean, we are at 9:30, but we're getting close to the end of this. Can we go a little longer and finish our review? Yeah.
I'm good to go till 10 o'clock.
Okay, thank you, sir. I'm hoping it doesn't even have to take that long. Any other comments, questions about that section we just looked at with the billboards, or are we ready to move on?
Move on.
Okay.
All right, so going into the next section here, we have the unauthorized placement activities. So if there is unauthorized placement activities, it would be declared a public nuisance and would be a violation with our code enforcement. So if we're good with that section, I'll move to the next one. So the next section, 87.2.10.5, gives the county the authorization to require removal of an existing billboard by providing the existing billboard owner notice of such intent, a minimum of 7 years prior to actual removal of the sign. So this is giving them an indemnification period, and this is something that can be determined by the Board of Supervisors if they determine that there's signage that should be, is that, I guess, an issue with the public.
It's just wanted to clarify one word. It wasn't indemnification, it's amortization period.
Sorry. Yeah, two different things.
Yes, yes.
And I'm speaking a lot of words. Too many things. So if we're good with that section, we can move down to directional signs, which was added directly from the coastal language, and nothing's been updated with this section here.
Okay.
This allows for directional signs with a square footage limit of 24 by 24 inches.
Commissioner Curiasi.
So on directional size, Part 2 location is another example where it is only, it's roadway focused, and I'm not sure if that's really necessary. You can have directional signs that indicate path of travel for bicycles or pedestrians.
Or pathways or trails and things like that.
That seems like a good point.
We'd be happy if it's the will of the commission to change that to be path of travel for pedestrians, bicyclists, or vehicles, and synthesize that throughout.
Okay.
Okay, I think we're all fine with that. So yeah, good suggestion. Thank you. For the sake of just being consistent, let's just quickly have a straw poll to that effect. All in favor say aye.
Aye.
Aye. To adding references to bikes and pedestrians in the directional sign section. Thank you. So yes.
Right. And then the permit required for that is a special permit. And so the next section we'll go into is design standards, and under this section we have illumination requirements, and this will, signs in non-residential zoning districts may be internally or externally illuminated except where specifically prohibited. And
So I have a question. So if you have a sign for like emergency locations, don't they get illuminated? Because I know there's other signs that you're saying only you can't use illuminated signs, but if you have like a fire department or something like that, aren't they illuminated?
That would be public agency.
Well, I don't think we're saying that signs can't be illuminated. We're saying they can be illuminated.
Okay.
I think the other confusing thing is where we were talking about the illumination of like the price signs. We're really talking about a different kind of technology to display the prices, whereby it can be manipulated from a computer, and so it's changed remotely rather than changing the face.
So if it's fire, emergency, or something like that, you can have them
Yep.
illuminated 24 hours a day?
Yep.
And moving from there, signs in residential zoning districts shall only be externally illuminated and must be located within 50 feet from any residence, just to protect from glare.
Okay.
Moving down from there, we have requirements for steady, stationary, and static and color illumination. They use full cutoff lighting, downward casting and shielding, and visors. There's also a section for not producing glare, and light sourcing for externally illuminated signs, again, must be shielded and positioned so that the light only directed at the face of the sign doesn't spill beyond where it is needed. And we corrected some of the language there, as I had said earlier, for businesses that operate past sunset, and made it so that they can operate their lights past sunset until they close. And exposed bulbs are not permitted. And lastly is the design features consisting of the neon tubing and things like that.
Commissioner West.
I am still stuck on the lowest light level necessary language. That, to me, is extremely subjective. What one person deems necessary is another person's excessive. Do we have tools in our toolbox to make that a little bit more objective?
So it is subjective by design, unfortunately, because it's going to depend on circumstance and where it's at. I think sign ordinances start to get into the amount of lumens that can be within a sign. We can certainly go there if that's the desire of the commission.
Was it in the other samples, were there limitations on?
Sonoma County does have limitations on illumination, which states that internal illumination must be limited to low-intensity lamps and letters and graphics with opaque background, and that external illumination is screened from adjacent roads and properties.
Is that what you're looking for?
I mean, we have great language for shielding, like for the position of the lighting. I think it's just the intensity of the lighting that is, I think it comes down to the director saying that is too intense or not too intense, and that changes by, it's just very subjective to whoever's deciding that day. And I don't love subjective code.
Appreciate that. So there's a couple of options here. One would be to use the language that Mr. Dunn just read, which would require that the face be more opaque, so it's not as translucent. The other is to just set lumen level, and I don't have something to propose to you on that off the top of my head.
I think for me, if we don't end up, this isn't something I want to hang my hat on for the evening, that to make us bring this back again. But if we do end up bringing it back again, I would love to see a lumen level.
Or, yes, Commissioner Kiriazi.
I concur as well. I agree with Sarah that I was stuck on that as well. I think a lumen level could be definitely a can of worms, but that's my preference to go more objective.
So potentially without, delaying our ability to move this along, we could take a straw poll on adding the recommendation that staff look into adding lumen level limitations and other objective criteria.
Or
on
just
lighting.
leave it to more objective criteria.
Yeah.
And we will either look at at using language requiring opaqueness or lumen level or a combination of both.
I'd be supportive of that. All in favor of adding that suggestion, say aye.
And that would go in 87.2.12.16, instead of lowest light level necessary, you would insert something around that, okay.
So, all in favor of that, say aye.
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 Any opposed? Nope. Okay. Sorry, were you wanting to say something right then, Commissioner Mulder?
We got to where we need to go, so let's move on to the next spot.
Okay, we got there. Yeah. Yes.
I would suggest maybe breaking it out into its own, so you have one operational hours and another entry as light.
Breaking that provision into one that has the hours, the other one has light level. Sure. Yeah, for clarity, that probably makes sense. Okay. We've made an exception for neon or other fluorescent gas in window signs, but as I read it, this is not, that's prohibited in any other signs outside of a window, correct?
That is correct.
Even with a creative sign permit? Or, I'm just curious if there would be a pathway for somebody to actually do a creative sign that involved neon? Or is this like, you know what I mean? Or is it absolutely prohibited?
Sorry, let me look back at the creative sign section.
While he's looking at that, I would offer that perhaps the thing that the commission could do is say it's prohibited unless approved as part of a creative sign program. Keeping in mind, though, a previous discussion that we had was part of the reason for not allowing neon is we were trying to minimize light impacts.
Yeah.
And typically neon does give more glare, more light spillover.
Okay.
We're making a certain allowance for it to be in windows, 25% of the window. But when you start making a sign neon, you're beginning to really change the amount of light that's being emitted.
That's a good point. Yes, Commissioner Mulder.
With hearing that, intriguing my mind of our last vote, it's like polar opposites almost. So I'm
yeah.
kind of not.
Okay.
I'm not leaning in support of that.
I will withdraw the suggestion then. Let's just leave it as it is. Yeah. Okay.
So moving down, we have the new billboards and off-premise signs, or new billboards, which we discussed earlier. Off-premise signs have been prohibited. And we have decorative signs, which I think from the commission's suggestion earlier was to remove feather banners from the decorative sign section or have the exception for the permanent sign table included in that section. Right.
Yeah, I mean, that was a good catch by Commissioner West. I think we just want to make sure that it's consistent with the earlier references.
Yeah, we can remove it.
Remove decorative signs altogether?
No feather banners.
Just, what about banners? We're allowing temporary banners, right?
Well, yeah, that's saying banners are prohibited except as a temporary sign, but feather banners we're treating more as permanent, like.
Allowances, okay, yep.
So, did you have any other comment on that?
Yeah, I think that my intention was, like, I would prefer not to see feather banners except for in limited circumstances like wave allowed. So if that gets at the heart of that, that's great.
Okay.
All right, and next is hazardous signs, which is signs that might adversely affect traffic control or safety. Creates traffic safety hazards by interfering with driver's sight distance, including signs visible from any public road, street, or right-of-way containing colors or reflective paint that blinds the vision of drivers.
And at the bottom of, well, it's not the bottom of that provision, but it says, or which makes use of the works.
Works.
And it should have been words, I believe. But I appreciate that you guys thought of this. Seems like a practical, sensible rule to me.
And then next is the obsolete signs.
Oh, yes, Commissioner Kiriazi.
Yeah, I think bringing up again is another example where it's very focused on cars, and I think that this is also applicable to people who are walking or biking. So maybe making a recommendation that staff take a look at the use of the word sort of drivers and expanding that.
I have a comment on obsolete.
Okay, well, yeah, well, we're not quite there yet because of this question about, I take your point, but I'm trying to figure out what sort of a change there would make sense with regard to.
For an example, you could be walking down a sidewalk, and if something is quite bright and making it hard to actually see inconsistencies in the sidewalk, it could be a tripping hazard. So it's not, this isn't just applying to cars.
Okay.
We could change driver to something to the effect of an individual's.
Okay. Are you all fine with that? I'm fine with that. Okay. Thank you. So then, obsolete?
Yeah, I have a comment.
Commissioner O'Neill, you have a comment?
So if a property, say a property closes down and it's for sale, and it takes longer than 6 months to sell, can there be an exception there to saying your sign's obsolete and has to come down? Because typically the sign would be part of the property that's for sale, and then you'd have to exclude it in your sales agreement and all that. Could there be an exception there if it's listed?
So this is really talking about the sign face. So
You
similar.
wouldn't have to take down the whole
No.
thing.
So similar to what happened in McKinleyville recently with Best Cleaners.
Mhm.
They closed. They just painted, it was a painted sign, they painted it white. That complies with that provision.
Because, there's a value to part of that infrastructure, and you don't want to have to say, but I have to exclude it from this price because I have to tear it down. Okay.
Yep.
Okay, so then we're fine with that. Commissioner O'Neill, you're okay with that understanding? Okay. Any other comment on that? No? Any other comment on any of these remaining provisions? Signs on public roads, signs on public property. Yes, Commissioner Kiriazi.
And the signs on public, in public spaces instead of on public roads. Just another example of potentially changing the road focus.
If we made it any public space, that seems like that could confuse things, because signs, okay, so let me just make sure I'm reading this correctly. So any sign is not permitted on a public road or public road right-of-way except as permitted by the Department of Public Works. But if we expand that to I guess what other situations are you thinking should be included in that?
I was feeling like maybe the intent of this section was for public space, but because generally we're thinking about roads, they put the word roads.
This was added as a suggestion by the Department of Public Works.
Who also maintains bike trails and parks and various other public spaces.
And which the signs on public property would address that. No.
Mm-hmm. Yeah, I mean, if it seems like that does sort of cover what I think you're getting at there.
Yeah, I agree. Yep, I agree.
Okay, but again, good questions. I know I brought up, or we had a discussion last time of roof signs.
The Mountain Mike sign.
Like the Mountain Mike sign. And I remember being of the opinion that, okay, something that's on the top of a roof that's extending the height of the building with something above the roof line, that I could see not wanting any of, but I didn't find it objectionable the way they had done Mountain Mikes. I don't honestly remember how we all came out on that and if anybody agreed with that or not.
I agree with that.
I think what we were intending to do that we evidently didn't get it changed was to identify that basically the sign can't exceed the highest point of the building.
Yeah.
Or maybe a percentage of the highest point or something. I mean, that was about a quarter of the roof.
Well, Mountain Mike's is on the false mansard. So it's just on the sloping portion of the mansard. So if basically you want to allow it on a false mansard with the parapet up behind it so that it's not silhouetting above the roof line, that's...
But that could be a pretty big sign if it, the roof is high. So, I mean, if you said, well, it couldn't be a percentage of the roof line, because you could make it as high as the roof, and then you got, I don't know how high.
And then that's pretty tacky.
That's pretty tacky.
Yeah, I would kind of agree. Could we possibly set an objective limitation that, it could be a roof sign if it is...
A percent, like you did on the building, it had to be a percentage of, you couldn't exceed a percentage of the space.
Yeah, like 25% of the window space.
Yeah, and you should maybe do that on the roof.
So...
I'm wondering if we're starting to make an additional appurtenant sign category at that point.
You're just limiting, here it says you can't do it at all. And we're saying you can do it on, what was the name of that you said?
The false mansard.
The false,
So if from the ground, it doesn't go above the, when you're looking at it, it's still got the parapet behind it, or it's still got the roof pitch behind it. And it's complying with the area requirements that we've established as being acceptable for the facade.
Yeah, that's going to limit it.
then we'd be okay.
I mean, isn't that really what you're trying to get to?
Yeah, I think you're right. I was forgetting that all signs have to be, they can't just be super high letters because that exceeds the...
Right.
Yeah. So...
I guess to clarify, you're saying that the wall category applies to this when you say the facade?
The facade.
Yes.
Yeah. It seems like that's where it would belong. Yes, Commissioner Mulder.
So I'm glad you brought this up, and from watching your hearing, that's very much like what you kind of had a consensus. I don't think you guys officially straw poll voted, but basically that Mountain Mike's was the perfect example of like, hey, a sign like this, but nothing like super high. I'm glad you brought it up because I would be in support of what you're speaking of right now.
Okay.
You couldn't have like the Blue Lake Casino Hotel where the sign's on top of the building.
Those are huge, yeah.
I didn't hear any consensus for that kind of signage.
Right. So is what is what we've discussed, director, sufficiently clear that we could have a straw poll to that effect?
Yes.
Yes, Commissioner Kiriazi.
And just one clarification, so facade is basically from the ground to the roof line?
Correct.
Okay.
Okay. So then all in favor of making that adjustment to the roof signs, say aye.
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 Any opposed? No? Okay, unanimously approved. Well, can we talk about anything else, or are we done? Yes, right. That brings us back to the recommended action on this item, and I would entertain a motion.
I'll make the motion with the agreed upon amendments that we called out. I don't know if that's appropriate term.
That you're recommending that we
Adopt the ordinance
that
with the recommended.
that we recommend to the supervisors that they adopt the ordinance with the conditions or with the additional changes we've discussed tonight.
Or additions and changes or clarifications.
Yeah. I think that's sufficiently clear. So we have a motion by Commissioner O'Neill,
I'll second that.
seconded by Commissioner West. Any further discussion before we vote on that motion? Then all in favor, please say aye.
Aye.
Any opposed? Okay, unanimous, motion passes unanimously. Thanks, guys. Good work and really great work by the staff in bringing this version to us. We are over time, but very quickly, Director Ford, is there anything you wanted to report to us?
Just briefly state that the Board of Supervisors considered the Valadeo subdivision that was appealed to them, and they approved it with a couple minor changes. They reduced a number of lots on Pickett from 4 to 2, allowed single-family residences there, but allowed those residences to have accessory dwelling units. And then they removed one of the multifamily buildings and a lot, so they reduced the number of lots from 19 to 16. But otherwise largely upheld the Planning Commission action. And then they started consideration of the short-term rental ordinance and asked for some refinements to the farm stay definitions, requiring that the good neighbor guide be provided to all short-term rental neighbors. And we're looking at some other things. And then they continued that to March 5th. So next time we meet, I'll have an update on that.
Okay. Any other quick discussion items? Commissioner Mulder?
So, very end of December's meeting, there was under report from planner, there was a statement about the commission kind of running over staff and not listening to staff. I apologize because I took part in that, I feel, kind of getting caught up in the meeting. And sometimes when we get late into the meetings, we kind of don't listen to staff. I feel like tonight we listened to staff. There wasn't a big hesitation, but I'm going to be more mindful in the future when the staff's like, hey, we should bring this back, or we need more information, to not send something forward to the Board of Supervisors that might get overturned. On that same note, the SDR ordinance, I know we put a lot of time, a lot of meetings, a lot of concessions, and hopefully that doesn't get too tweaked and too changed over, because I've never seen such good governance between staff and the commission and the public on that. So everyone, good job on that.
Yeah, well said. Thank you. Okay. Anything else? If not, then we will adjourn. It is 9:57 and we'll be back on March 7th. Thanks all for staying late tonight.